May I please address? I beg to mention item number 2 of the Delhi list.
It's no item 2 here.
Division. Division publishing. Actually, in this case, the advocate came or is there, but he is serving. So I'm appealing. Is ordered in a criminal case 201. It's a bail order that is by this honorable division bench. And we have some by this IA for modification of only one condition, which is that page number 26 of our petition. That petitioner was directed not to leave jurisdiction of Arunachal Pradesh without leave of the trial court. Condition number 2, page 26. So let's say now problem is that his family members are in Tinsukia, and he has 2 cases, one at Dimapur, another at Arunachal Pradesh. And in both the courts, the same jurisdiction, he cannot leave the jurisdiction of the trial court. Now, NIA has also challenged the bail order granted by this honorable DP before Supreme Court. Now, he has to frequently meet his lawyer at Guwahati, at Delhi, and his family members at Tinsukia. For that reason, our simple prayer is that if that condition is modified to the extent that he will not leave the jurisdiction of this honorable Guwahati High Court, then it will be easier for him, and he will be allowed to leave his family members at Tinsukia. That is the only prayer to have.
You see, the difficulty is the provisions under which he is charged. We must have an ascertainment of where he is, because if we enlarge that scope, then we don't know what happens. Because how can the trial court keep a track of his movement? How will the security authorities, they will keep track of his movement? Because it's very easy when you refer to Nagaland, it's very porous border, which appears from the newspaper reports where it says that the people even today it was there that some MLA in Arunachal was shot dead. They said it's very easy to cross over. Yes, I'll hear you.
As it is.
And just tell us one more thing. Let us assume that he is to travel to Nagaland to attend the NIA court. Why can't take a leave from the court and then go? Because you see, in every trial court cases, dates are fixed. It's not that suddenly you wake up one morning and then find, oh, today is the case. Not like that.
I was coming to that. In fact, Lordship has not said that he will not go out at all. He can go, but he has to inform them. That is, I think, fair enough, Lordship.
Because the dates are fixed. Why the difficulty?
Now he has to take permission from both the courts in Dimapur court itself and again for.
Right, because you see, let us say a man is accused of crime in 10 courts. We can't say that once he's appearing before one court, the other court shall relax conditions. Conditions of bail, we find it very difficult. Let us discuss. Anything you want to say more?
Court has not said that he will not go out. He can go out, but only thing is that he has to inform the court. This particular matter pertains to Arunachal, where most of them definitely he has to inform the court. It's not that he is.
Yes, Mr. Vora. Take a seat. Take a seat, take your breath.
Well, now we have a very small prayer. Just to not to leave the jurisdiction of one. That man change.
Sure. Mr. Bora and Mr. Chaudhary, please tell us, the query of the court is that when it is only for the purpose of tracking his movement from one place to another, and considering what the petitioner has projected, can we have it that the application for in terms of this clause 2 of the bail order, can we say that this application can be moved through a lawyer but sent through mail? These applications, can it be exempted from personal appearance and then send it through a mail, because the idea is to keep track of him? What is his movement when he shall return back on those dates? Assuming for a moment that in a particular day he wants to inform the court and take permission. Can we devise this method?
It is only a matter of informing the court. Therefore, I do not think a formal application like moving the court is not necessary.
No, we have used the word permission, prior permission.
Yes.
Prior permission envisages, even on administrative side, some
Yes.
yes by the trial court.
Yes, that is for that. Anybody has to present our application in a court.
Person.
In person. That, of course, lordship can. That will make things easier also.
My contention is why I recite said something like.
No, that condition is, we are not inclined to modify. But that gives a wider jurisdiction.
Yeah, I'm asking for the under Guwahati
No.
jurisdiction.
Because then who'll give the permission? You see, the magistrates and the trial court judges, they are bound by territorial jurisdiction, which is defined. Supposing he is in Guwahati, what do you call, the trial court magistrate will not say that.
Like if I leave Guwahati, jurisdiction of Guwahati High Court, then I need to take the permission from the
Oh,
court. That is
yeah.
my prayer. But because now I have to move, because the trial has started, sometimes I have to move to the Nagaland.
We are permitting you to move it by email. Let your this application, let it be presented by a lawyer. We are exempting our personal appearance only for the purpose of this application. So why we should enlarge the jurisdiction of your travel?
But every time I have to be there.
Has to be, because of the nature of offense.
Because they have not started how long, my lord? They have one thing, my lord, also can you consider? In one case, trial has started on no witnesses have one against charged.
In this application, that would be a premature assessment. You are only wanting modification of the conditions. You are inclined to.
These are the happenings, my lord. They know that one case they have even start to charge frame, one case trial started. The same case, not even the two different cases actually. Same case, two different places, I reside in different place. Delhi, they have also filed it. So these are the things, that's why we are asking for, we are not asking for much.
No, you see, the allegations are, we know what the allegations are, we not repeat it.
Allegation is that part, Lordship is already considering that bail has been granted. Now, after granting also, I have never violated any condition till date. I am complying both the courts with the order. Now, because of these circumstances, I have been before your Lordship just to simple modification.
No.
That's I'll leave it to your Lordship. If Lordship is
But
pleased, then Lordship.
You can, we'll permit you to move it through a
Yeah,
lawyer
leave it
by
to your
email.
I'll
By
leave it to your
email.
Lordship.
for Mr. A.M. Borat and the senior counsel, assisted by Mr. uh, B. Bhagavati, counsel for the applicant. Also, had Mr. R.K.D. Chaudhary, Learned DSGI, appearing for the respondent. As far as this application has been filed for modification of the relaxation of condition number 30 within bracket 2, Roman 2, small, which was imposed while granting bail to the applicant by an order dated 27/6/2022, passed by this court in criminal appeal number 201 of 2020. Next, the learned senior counsel for the applicant has submitted that the applicant is facing trial in a connected prosecution initiated by the NIA, comma, being, what is that number? That at Nagaland,
The special case, my lord, yet to be registered. That is, my lord. RC10,
okay, RC, just like that, RC10,
RC10 oblique 2019 oblique NIA oblique GUW.
And paragraph 11.
okay. Where charge sheet has been filed against the applicant under section 120 capital B, oblique 384 IPC, read with, not read with, as well as section 17 of the
UAPA.
unlawful activities within bracket prevention, bracket close act, 1967. And in connection with this said case, the learned NIA court, Dimapur, had granted bail to the applicant with a condition not to leave the jurisdiction of that court without prior permission. Full stop. Next, it is submitted that the applicant was granted bail by this court by order dated 27/6/2022 in connection with NIA case number RC-03/2019 oblique NIA NIA oblique GUW under section 302 oblique 307 oblique 34 IPC and section 25 within bracket 1B bracket closed small b oblique small a, sorry, within bracket small a oblique 27 of the Arms Act and section 10 oblique 13 of the unlawful activities within bracket prevention bracket close act. And therefore, as per the said condition imposed by the court, the applicant is required to move the jurisdictional court at the court of learned special judge within bracket NIA, UPR. It is further submitted. Next paragraph, it is further submitted that the respondent has filed an appeal before the Supreme Court of India in connection with order dated 27, sorry, no, against the order dated 27/6/2022 passed by this court in criminal appeal 201 of 2020. And therefore, he also has to interact with his learned counsel at Delhi. Next one. Accordingly, the learned senior counsel for the applicant has submitted that the said condition contained in paragraph 30 within bracket small 2 of the order dated 27/6/2022 be modified by permitting the applicant to remain within the jurisdiction of this court instead of limiting the movement of the applicant to the jurisdiction of the learned trial court at UPR. Next, the learned DHA has opposed the prayer on the ground that it would be difficult to track the movement of the applicant if the jurisdiction of travel is enlarged. Next para. We have considered the circumstances under which this application is being moved. So, having regard to what has been submitted by the learned senior counsel for the applicant, the court is of the considered opinion that the nature of the direction contained in paragraph 30 within bracket Roman 2 of the order dated 27/6/2022 is a prohibition to the applicant to leave the state of Arunachal Pradesh without prior permission of the learned trial court. First of all. Therefore, what is required is the intimation to the learned trial court before leaving the jurisdiction of the state of Arunachal Pradesh. First of all. It is a usual practice of the trial court to fix another date for appearance, and therefore the applicant would be aware of the dates on which he is required to appear, either in the state of Arunachal Pradesh or in the state of Nagaland. So therefore, to facilitate the applicant to move the learned trial court for seeking permission to move to leave the jurisdiction of the concerned states, the concerned state of Arunachal Pradesh. The court is inclined to provide that it would be permissible for the applicant to send an email to his learned counsel engaged for his defense in the court of special judge within bracket NIA, UPR, Arunachal Pradesh, which can be filed by the learned counsel seeking permission from the learned trial court to leave the jurisdiction of the state of Arunachal Pradesh. First of all, it is provided that in an event such an application by email is filed for the learned counsel for the by the applicant through his learned counsel, the learned special judge within bracket NIA, UP shall consider the same, and such an application by email shall not be rejected merely on the ground that it was not physically presented by the applicant. And it will be open to the learned special judge within bracket NIA, UP or Arunachal Pradesh to grant leave to the applicant to move outside the state of Arunachal Pradesh on the strength of such an application. Stop. Next one, according to the this application stands partly allowed by partly modified in the condition of Roman 2 of paragraph 30 of the order dated 27/6/2022 passed by this court in criminal appeal number 201 of 2020.
My case, Lordship had mentioned 2015. This 3 of 2009. Lordship will find out that page 15 of I Lordship is mentioned there. Lordship accept 3 of 19 is the Dimapur case.
Acha, that means this no, because you see, I'm quoting this from page 14, 1-4. I have written, no, it's not that, I don't know because,
Some type of.
no, it's okay. Mr. Bora will know better. It's 9 or 19, it should be 19, I think. 19. No, it's okay. It's, not apology, but I was referring to something when I was dictating. Yes.
Similar prayer can I move to the Nagaland court also?
Pardon me?
Similar prayer, whether I can move the same prayer in the Nagaland court also.
We won't say anything because that is the exclusive jurisdiction of that court. We don't need to give any liberty. You see, it's a separate bail order. In separate bail order, why should we what you call assume jurisdiction and grant you liberty? Because once we say something, we are assuming jurisdiction that we won't have.
For that, I need to have a separate.
I think so. Will depend on your wisdom. We say something, it will be enforcing your jurisdiction.
No. Even the, don't take it otherwise. I'm very surprised to see the small accused. He can't even be tracked by the NIA all over the country.
No, don't be surprised. You see, we can give a direction. We can direct you to be instilled with a what you call GPS and do so because these are a condition
These are the conditions.
No.
In America.
in America. Huh?
Yeah.
So we can do it.
No, I'm not on that part. I'm saying that if the organizations like NIA, you can track everybody, but if they can't track me in the.
No, please don't make those comments. They are very loose comments and it affects the administration of justice. Why? I'll tell you.
That's,
No, you'll take an exception of that submission. I'll tell you why.
No, I'm not making, I said, well, don't take it otherwise.
That's okay.
That's why I started
leave
with
it.
that.
Because I have reasons I can tell you why. Why I think so.
That's why I'm saying don't take it
No,
otherwise.
it's okay.
The-
It's okay. No, it's not required. When he says that, he's just
I
saying.
started with that, probably logic is that one.
No, that is okay. But it's not a question of taking offense. I said that I have an answer and I will give it.
That's a different matter. That logic has said that the logic has taken differently. That's why I'm saying, well,
No,
because the
something,
liberty of the person, man, if the person lives in somewhere else. He has to move somewhere else.
we have a reasons, Mr. Bora. We have a reasons.
These 4 areas now.
We have a reasons. You see, that is why in a lighter tone. Again, don't take an offense with what I am saying.
And then logic, we have to go by that
No.
judgment also.
I'll tell you what. You see, it's very easy to attack the institution when the institution doesn't respond. Correct. You may make your own submissions. You can, what do you call, question the wisdom of the courts at all stages, not only from the trial court up to the Supreme Court. Because we don't have a mechanism to retaliate and to inform why we take such a decision, why it is there. Number two, the decision-making process is something which is very personal to the legal process which we are doing.
I'm not.
And
saying-
no,
I'm
no,
talking
I'm
about
telling you.
Yeah, but
I'm telling you.
I'm
So
not-
therefore,
saying the High Court or the, I'm talking about the NIA.
no, it's
That's
okay.
such a
We
big
won't,
institution.
we won't make a,
That's why I'm saying that.
we won't make a comment. We won't make a comment because of the fact that what you are suggesting would be in violation of the judgment of the Supreme Court of India in the case of Puttaswamy. Puttaswamy says that despite whatever, the surveillance of a citizen cannot be made by the investigating agencies. And that is the reason why we can't order that for each and every citizen. Let us say that the NIA in one particular day, let us say tomorrow, is a day when the offense in respect of NIA offenses multiplied to 1 lakh. There are 1 lakh accused in the country, all charged with offense under NIA. So for 1 lakh, if there is a surveillance done, are you aware how much manpower will be required for one surveillance?
That's what I'm saying.
Can you tell me for one person if a surveillance is
The other way
made?
also. The other way also.
No, this is the answer I know. That's what I'm asking you. Can you tell us how much people are required for one surveillance of one person?
That's how many, that question.
No, no.
I
Please
think-
don't. We are not encouraging this debate. We're not encouraging this.
Started, that's why I'm just
No, no.
telling you. I'll leave it to the last.
Gone to Dibrugarh due to illness of his mother.
Adjourning. Please be here. Yes. 38. Okay, your phone? Okay. You have informed the other side? Okay, with consent of the other side, Mr. M.K. Sharma, counsel for the applicant. Sorry, respondent one, place for adjournment, prayer is allowed. List after ensuing winter vacation. We'll take it up at 2 o'clock. This matter, Jaji will upgrade it and take it up at 2. Who is for the forest is for the other side? SC Forest. SC Forest. At 2, okay.
I take the next for listing on second April.
Listing, give it to the court master.
But I have the approach manner, but not allowed to.
Oh, okay.
I get my lord.
What is the urgency?
My lord, Lanet, trial court, my lord, partly decreed the.
Oh, it's a new matter.
Yes, ma'am.
Okay,
So some finding is against me, my lord.
okay.
On 21 or 22.
The court master fix a date. We'll accept it.
We have filed a land acquisition appeal on 8/12.
This will go after vacation. Because we'll not be able to manage. And that's not the. You will fix it on the reopening immediately. Yes,
Making this mention on behalf of this KDB for item number 39.
39.
The respondent, due to her personal difficulty, your lordship, the matter may be adjourned, your lordship, and may be taken up after the vacation.
Okay, you have,
Outside has been informed.
you're taking consent? You are making prayer on behalf of? Okay. With consent of the other side, Mr. KG Sekia, learned counsel Praise for adjournment on behalf of Mrs. K. Devi, counsel for the respondent. First of prayer is allowed. List on. After Bihu vacation, you are saying 19/1/2024.
With the consent of the other side, I beg to mention item number 42.
42.
But there is not well. Pending, adjourn the case to the
Okay. You're on behalf of?
RK respondent.
Okay. You have taken consent?
Yes,
Okay, with consent of the other side. Mr.
is. AC,
A. Singh.
A.
A. Singh. Counsel for respondent numbers 1, 2, and 4, praise for adjournment. Prayer is allowed. List after ensuing winter vacation. An interim order is operating here? Okay. Oh. Okay. On the prayer made by Mr. N.G. Chaudhary, counsel for the applicant, petitioner, the matter stands adjourned today. List after ensuing winter vacation. Okay, then give a fixed date after after this winter vacation. Give a fixed date. Interim order passed earlier stands extended till the next date of listing. It will come in motion only.
8-1. I beg to mention item number 50, supplementary list.
50.
Worship, the council holding the brief is out of station due to some family medical emergency. Should
Okay.
we inform me to pray for an adjournment?
Okay. On the prayer made by London counsel for the appellant, matter stands adjourned today.
Should we list the matter after the incident?
List after ensuing winter vacation.
46 arbitration appeal 3 to nothing 49 to open 4402.
Supply item 46 for delivery of order. Arbitration appeal 3/23.
For the reasons assigned in this order, which are different from reasons given by the learned District Judge Jorat, this appeal fails and the same is dismissed. If some correction, you will get it after some time.
Item 47.
Court is inclined to alter, modify, vary the ex parte interim order dated 24/7/2023 passed by this court in the connected writ petition by providing that if the said opposite party number 1, that is the writ petitioner, namely Iajul Haq, has encroached any part of the public road covered by DAG number 3854 of Revenue Village so-and-so, the protection against eviction by interim order dated so-and-so passed by this court in connected writ petition would not be applicable and available. And the concerned authorities, including the district administration, shall be free to take such appropriate action as they may be so empowered or advised for removal of any encroachment on public road by the opposite party number 1 in accordance with law.
Item 48.
What is the correction you are requiring?
correct, for that, date of judgment and award date is 14/8/2023 lodging. That here is a lodging 14/8/22 instead of 20.
It should be 23.
And MSCT number 3 lodging. Motor accident claims learners number, motor accident claims number 3 lodging.
Number 3, okay. MSCT is MSCT, member MSCT, number 3, Kamrup Metro Guwahati. And award dated 14/8/2023. Rest is okay? Okay, correction.
IA also has the same correction. Date of
In,
judgment,
in IA also, same correction,
same correction.
in IA also.
I have corrected.
Okay, okay. We modify it.
Item 48. 49. 49.
It should be Chief Judicial Magistrate,
It should be special judicial magistrate Kamrup Metro.
Special Judicial Magistrate.
Special judicial magistrate, first class also. Special judicial magistrate, first class Kamrup Metro.
Special Judicial Magistrate, Kamrup Metro.
First class Kamrup.
If it is Special Judicial Magistrate, it's not first class. If it is Judicial Magistrate, then we say it's a Judicial Magistrate first class,
Yes, yes.
correct? Okay. Make the correction. Item number 1. You have seen that? No, sir, you have a pertinent question. It's not a, you see, if the original order is without jurisdiction, we can't take up the adjudication. It has to go back. Inherent lack of jurisdiction. Second appeal can't be adjudicated by the district judge. It will be inherent lack of jurisdiction.
Dear Lordship, this suit was dismissed. Again, this should identify the first appeal. Then first appeal was finding of the trial court was reversed. Then it was remanded back under order 41 rule 23A, saying that the commission, a fresh commission to be appointed.
Remand was by which court?
Remanded by civil judge in
Appellate court.
Now, that is an lordship order. It comes under order 40, section 104(1)(I). Read order 43, rule 1(q). And that order is an appealable order. Now, lordship, against that remand order, both the parties filed FAO.
No, will it not be second appeal against order? Now, supposing in second appeal, if I pass an order of remand, it would be the first appeal before Supreme Court.
Can we see our proposal?
Yes,
You can we see appendix 32.
yes,
What is the category of cases? Lordship, can we see the first appeal? Left hand side lordship.
which page? Which page?
464.
464.
Relevant portion lordship.
Yes, yes,
Can we see the first appeal?
yes,
Here lordship, can we see the second MFA 10221. Appeal under order 41, rule 1 CTC relating to temporary investment.
yes,
Then lordship, MFA 1022. Order appeal under order 41, rule 1 CTC.
Yes.
Specific.
come to page 470.
Yes.
Entry number 100. Appeal from appellate order.
Yes. Case is under order 43.
No, but you see, every court has the power to remand. Now, if the power of remand is exercised in exercise of the first appellate jurisdiction, then naturally anything there would be second appeal against the order.
Because this first appeal, category of first appeal lordship, the order appeal under order 43, rule 1 CTC is very specifically mentioned. If you lordship see the second appeal, second appeal against the second appeal against the order, there is a different column. Second appeal column and the first appeal column is different. And lordship, it is not that we have filed the appeal before the Honorable Guwahati High Court lordship, both the parties, right? Now you can see appendix 34, page 474. Now the first appeal lordship is FAO.
Just a minute. Yes,
Appeal from order. Page 474. So under this lordship, we have filed the first appeal before this honorable court. Now lordship, this honorable court has transferred the matter to the district to decide the matter. That order is not here lordship, I would not see that order. But lordship, now thing is that whether district judge has jurisdiction to entertain an appeal against the order. Now lordship, what the civil courts rules and order.
Civil court rules and orders. Civil court rules and orders. Yes.
Case. 330, the same degree. 330.
330. Yes.
Second, 4,
Yes.
miscellaneous appeal.
Yes.
The following are classes as miscellaneous appeal. 1. Appeals from order under section 104. Order 43, rule 1. So, Lordship, both this court, High Court and the civil court has jurisdiction to entertain an application under order 40, rule 1. Now, Lordship, only thing is that the pecuniary jurisdiction. Now, Lordship, kindly see Bengal, Agra, and Assam civil courts. Lordship, kindly see the 20, section 21.
Yes. We have it.
তেওঁলোকে বুক লিষ্টখন এইমাত্ৰ কোৱাখন পোৱা নাই এই কনচেপ্ট বেংগল আগ্ৰা
It we have Pava. Okay, Pava. Assam. It was Assam.
This is after amendment.
Yes.
Appeal from civil senior division and civil junior division. Said as a court said, then appeal from a DP or order of a civil senior division shall lie with district judge where the value of the original suit in which or any proceeding arising out of which the DP or order was made did not exceed so and so this evaluation was and to the High Court in any other.
Just tell me one thing. Let us say in the trial court, in a suit, there is an injunction application. Again, in order of injunction, there is a first appeal under order 43 rule 1. Now, against that, you file an appeal before the High Court. In the High Court, you again file an application under order 39 rule 1 and 2. Correct. We pass an order of injunction or refuse it. So again, there will be a first appeal before the Supreme Court under order 43 rule 1R because it's a jurisdiction, original jurisdiction under order 39. And then the only question we can smile at is that what happens if the division bench of the Supreme Court passes an order under order 39 rule 1 and 2? So you see, we have classified in a civil code, Bengal Agra Assam Civil Codes Act, the jurisdiction with defined as original jurisdiction and appellate jurisdiction. If an appellate jurisdiction is exercised, then the order against which an appeal is there would normally be in a class of second appeal, because then we say that under in order 39 1 and 2, if there is a first appeal and there is an order, then again that is sent to revision. That is the normal idea we are having. Although I have not made any research on that, but against the appellate order of 39 rule 1 and 2, we don't find an appeal under 43 rule 1R. So I am taking cue from that.
It is correct. But if Lordship sees the order 43 rule 1, first if Lordship sees the section 104. 104 is very specific because Lordship knows this first appeal is appeal against original decree. Section 100 is appeal from appellate decree. That there has to be a decree. But 104, it says appeals from order. Order from which appeal lies. An appeal lies from the following orders and save as otherwise expressly provided in the body of this code or by any law for time being in force from no other orders. Then I is relevant for our case. Any order made under rules from which an appeal is expressly allowed by this rule. And it is allowed by order 43 rule one. If lordship sees the categories lordship, they belongs to the same rule. If lordship see the language of you, it says an order under rule 23 or rule 23 or order 41 remanding a case where an appeal would lie from the degree of the appellate court. So appellate court has been said, and it is order also, and it comes on.
No, no, please read that again. Please read that again. If an appeal would lie from the order. So you see, if first appeal jurisdiction is exercised, and then order 43 rule 1, sorry, this remand is made under 23A, an appeal will lie where? Read that section, it will be very clear. Where will the appeal lie?
An order under order 4. An order under 23 order or order 41 remanding a case where an appeal would lie from the degree of the appellate court.
Where an appeal would lie. So therefore, it is very clear if it is a trial, the appellate court remanding, then we come to the High Court, saying that the remand order passed by the single what they call the first appellate court was without jurisdiction, and therefore we entertain the appeal here. Correct. So against that, the original appeal would not lie before the district judge, because the appeal would lie is only an appeal under section 100 and nothing else.
So this is
See that?
within 4 is-
No, supposing that remand order, you want to file an appeal, where would you go in a first appellate forum? If the order is passed by the first appellate forum, the appeal would only lie before the second appellate forum.
This appeal, the 43 is categorized as a first appeal.
No, you see, it's not the question of category. Irrespective of the category, can we permit multiple appeals just because an injunction application is filed or just because there is an order of remand? You see a situation where the first appellate court remands the matter to the trial court. Then there is a first appeal. In that first appeal, again there is an order of remand directing the trial court, the first appellate court, to rehear the matter. Again, we entertain a first appeal in the High Court. High Court again remands that no, you all are wrong. We remand the matter back to the trial court. Again, there will be a first appeal before the Supreme Court. That's not every time there can't be a first appeal.
For my submission, or as the our rules and Supreme Court's rules and order, which are them under section 122 or 125 CPC. It categorizes this order 43 rule 1 as a first appeal. And lordship from the civil senior division, the High Court and the civil court division and the jurisdiction to entertain appeal. Now this lordship, both the parties approach the High Court and file this appeal. It is the High Court who has directed the district judge to decide the appeal. So this lordship cannot be regarding this lordship.
Just a moment, let me write it down. You are first referring to page 100, 300, 400, 464. You are referring to entry MAF.
The category of first appeal.
Yes.
This is very specific. 41 rule 1. It doesn't single out the U differently. It is inclusive. U is inclusive.
Yes. Second entry you are showing as
Appendix 34, page 474. Therefore, is the first appeal for orders.
Now, please come to page 465. This again under second appeal, there is second appeal against orders, MAS. No, I understand. But please tell me what can be there under MAS then?
Definitely not this, because this is very specific.
No, it's okay, but just think of, because as a student of law, please tell us what can be a second appeal against orders. That is page 465 and 470. 470 you will find entry 100, second appeal against orders. Now, what on earth can be second appeal against orders?
Specifically categorized.
So therefore, against an order of injunction, if there is an appeal against that, there will be a second appeal against orders. Then you are referring to 742. No, in the High Court rules, you are referring to something else? No, or only these two. Okay. Rule 742.
Appeals from orders under section 1041, order 41 rule 1. Now, let's say this makes it clear, let's say, because order 41 rule 1, it includes you also. So it's made appealable before the under the civil rules and order as a misappeal. It will be categorized as misappeal before the district judge and FAO before the high court. he ordered after this with the senior division, it is made available before the district and high court. Both has to be, but pecuniary limit is there. He had given to judgment. First one is 2007, 13 HCC, 293. Yeah, yeah, Lordship in the appealing Lordship regarding court commission, it was allowed, and regarding cross objection, it was rejected. Lordship. Paragraph 9, Lordship will find that. Then para 11, submission was there.
Just a moment. Para 9.
Para 9, Lordship will find that there are two parts, Lordship. One part is a court commission regarding that it was allowed, and regarding cross objection, it was rejected. And this single second appeal was filed. In para 11, look at the submission.
Just a moment.
There in the para 7, 8 also.
Yes. After 9.
11 submission. 1. Having regard to the provision of order 41 rule 1, sub-rule Q of the code, civil procedure, the second appeal was not maintained. So the submission then para 12 other side submitted the appeal referred by the respondent being a composite one, vote against the order of dismissing the.
No, just a moment. Something wrong.
And also second appeal not maintained. Then what can be-
You are referring to 2023 SEC online. Oh, 2007 13 SEC. Oh. Is para 9, please come again. An appeal preferred against or cross objection.
By the respondent there, while rejecting the set of that commission, post commission, it was allowed, and so the submission is 11. Having regard to the provisions of Order 41, Rule 1, Sub-Rule 3 of the Code of Civil Procedure, second appeal was not maintained because they are 5-1. Then submission of the other side is 12-1. The appeal preferred by the respondent being a composite one, both against the order of dismissing the cross objection, as also the order allowing the appeal preferred by the appellants, a second appeal was maintained. Since the argument on this point, then Lordship 23. It may be true that in view of the Rule 1E of the Order 43, a second appeal was not maintainable, but the scope of an appeal under Section 100 of the Code of Civil Procedure is narrower. If the appeal had been entertained upon hearing both the parties, this court may not exercise its extraordinary jurisdiction to exercise that order. As what matter more is to see whether substantial justice has been done to the parties and not the technicalities involved therein. In a given case, the appellate court, in exercise of its inherent jurisdiction, can convert one type of appeal to other. Forum for preferring a second appeal has also an appeal under Order 43 Rule 1U is the same, namely the High Court. As the scope of an appeal under Order 43 Rule 1 is wider than a second appeal, the appellants on their own claims are not prejudiced in any manner. If the High Court proceeded to consider wisdom in the appeal in its instant judgment, even substantial questions of law were framed and same have been answered. We, however, also agree that technically a second appeal was not maintainable for one part of the judgment, keeping in view the fact that the matter is pending for more than 40 years, and in view of the nature of the dispute, as also the quantum of amount involved, we are of the opinion that it is not a big case where we should exercise our discretionary jurisdiction under Article 136. It is now well settled that the court, so it has said that the distinguish the second appeal and appeal under Order 43 Rule 1Q. Now, in our case, we consider that we have filed this before this High Court. Since there is two forums having jurisdiction, High Court has demanded that directed the district judge to decide the matter. It is not that district judge doesn't have the jurisdiction. So in this case, Lordship, there is no lack of jurisdiction in my respectful submission, and therefore it cannot be termed as nullity. Yes, if the argument is made that it is the irregular exercise of jurisdiction, then also, Lordship, it cannot be termed as nullity. There is a provision of appeal or revision, whatever it lies. Now, here in this case, Lordship.
No, we have another aspect. It's a well settled law that even by consent or otherwise, jurisdiction can't be vested. So therefore, if the let us say that we have sent it, but the inherent lack of jurisdiction can't be curtailed merely because the High Court has sent it.
But one thing to point out, High Court has not sent it. What happened in this case, regarding at that point of time when pecuniary jurisdiction has been enhanced, there was a general order has been passed that all the appeal regarding pecuniary first appeal, it should remand, it should go. There is no order from this High Court. There is no order from this High Court. The record of the record has been sent. Record has been sent. So, Lordship, in this particular case, there is no lack of this. And Lordship, can we see, there is none has raised any objection before that district judge or before any other court, Lordship. When this order of the first main order of the first appellate court has gone against them,
then only they have raised. Now, Lordship, this second case, Lordship, but my submission is, Lordship, that in maximum, Lordship, which also found no one shall be prejudiced by an act of the court. Regarding that, Lordship, the second judgment I, because we have approached Honorable High Court. In our case, Lordship, this civil rules and order have civil code civil and order is there, Lordship. Which came under the CPC. The second. That order prejudice no one. Lordship. Because this appellate court has finally passed an decree. And it is an independent finding, Lordship, not dependent on it, except that one sentence that earlier predecessor has demanded the
Just a moment. The High Court note says that this record is not available. Therefore, we'll have to call for the records of, you have applied.
registry's notice that record has been sent.
So therefore it's not available here, but in
Not
this,
available.
we'll need that order. Because he's otherwise right, if the High Court has vested and nobody had complained about it, the mere entertainment of that appeal, if it is not prejudiced otherwise. So, no, not that you see, it's intricately related to that order of remand. If that order is without jurisdiction, then
File
if assuming that if I take a view that the original order of remand was without jurisdiction, then the entertainment of the first appeal itself would become bad in law.
There is lack of jurisdiction.
No, apparently, the prima facie view is that it has got inherent lack of jurisdiction. Because if that jurisdiction is not there, then even the High Court, in its exercise of its appellate jurisdiction, is not empowered to vest jurisdiction on some other court. It was an error. But the question is only that whether on the ground that no prejudice is suffered, as because the parties had participated, this last submission you are making. It's only with that we have to examine it.
Discussion is there.
In some of the other cases also, in one of our cases, same situation arise. We had to file a miscase before this honorable court, and by passing of the order, it has been called for from the concerned district judge.
Which paragraph?
There are some anomalies took place in the registry, my lord. It is not that court has passed the order.
Your lordship, it says, my court must satisfy itself to the existence of jurisdiction.
No. You see, that can't be acceptable because of the reason. It's the order of the Honorable Chief Justice which is passed, and then the matters are sent back. Correct. So it's a general order and it will be applicable for all. If you are transferring in bulk.
But general order, but whether in this case.
No, you see,
In this case, it is a-
let me tell you. Let me tell you.
Demanded.
No, let me tell you. Assuming in a case I pass an order that all matters of Mr. Ghosh will not be listed before me. Correct. I just say that in one case I say that it not be listed before me. It goes to the registry makes a note. And then matters which are of you are taken away by this court, from this court, and given to allotted to a different judge. So you see that assuming in one case, it's a review where the matter is tied up with me, or it's a bail which I have rejected, so it is tied up with me. Even those get released. And one cannot say that they have got prejudice because no specific order was passed in that case, taking away that brief from the, the file from this court and given to a jurisdiction of another honorable judge.
What happened in that time, in the year when pecuniary jurisdiction has been enhanced in 2004, in one of the cases, my lord, our case, it has been transferred wrongly, like FAO. FAO has been transferred. We filed application before this honorable court for bringing.
Oh, we have heard that you have said. You see,
After that, my lord, Honorable Justice H.N. Sharma passed an order in that case that FAO nomenclature should be read as SAO. Then thereafter, High Court rules and order has been changed from FAO to SAO has been done.
no, you see, those are.
That is why, on the basis of
No,
nomenclature,
not
they
that.
have sent all
But
the
if
cases.
we can still take a view that if no prejudice is caused in
Even-
that adjudication when the parties had participated,
But lack of jurisdiction is there, my lord.
we'll see that.
Chief Judge has entered.
We'll
a
see that first.
negative-
First, we'll have to get that record.
And if that be
Just
so,
a moment. Let me see this judgment.
there, all
Just
these
a moment, let him
FAO should
complete.
be filed before the
Mr. Ghosh, let
judge.
him complete. Let him complete his submission.
Must satisfy itself that the existence of
Which para?
jurisdiction. In this case, in this column of it, Fourth mark satisfaction as to the existence of jurisdiction. Various foreign government, English government, between.
You're reading where?
I have two flag marks.
Yes.
The first flag mark. Fourth mark satisfaction as to the existence of jurisdiction.
Okay.
So it's discussed various judgment, foreign judgment also discussed, then also come to the next flag mark. Therapy. Having dealt with the aforesaid principle and making it applicable to the courts in India, we are inclined to hold that any failure on part of the court to do so would draw legal magazine, factus, curium, neminem, and gravity. No one shall be prejudiced by an act of court. As a consequence, in a case where a court has failed to set its jurisdiction, NFG has been raised subsequently, and that too after receiving an adverse verdict, the forum shall not be declared as one having lack of jurisdiction, especially when there is an apparent injury otherwise to the right conferred under particular statute. So here in our case, Lordship, section 21 gives the jurisdiction. Civil portion rules also give the jurisdiction. And we have approached rightly, Lordship. We cannot be faulted, Lordship. Both the parties have challenged the same order on the same ground. Both the parties did not want any press, commission. And there are other documents also in place.
Let me still will make one attempt to get the records of Misappeal 4, Misappeal 3 and Misappeal 4.
There are just two municipal Lordship. Then,
What is the numbers of the appeal? 3 and 4 or 4 or 5?
2008. Lordship, FAO 46.
No, 2008.
No, 4.
Two municipal Lordship.
No. What are the numbers of 2 misappeals? One is 4, one is what? 3.
Of 2008.
FAO 46 is renumbered as municipal 3. FAO 54 is municipal 4.
Mr. S.K. Ghoshal, counsel for the appellant, and Mr. J. Rekal, counsel for the respondents. Next, I've seen the office note. Dated 16/12/2023, indicating that the records of FAO 46 of 2004 was transferred to District Judge Dhubri. Wide number, all capital, HCXVI /2341 FA, dated 16/11/2006. Just one. The requirement of the said record is discussed in the order dated 12/12/2023. It appears that the said record is re-registered as Misappeal number 3 of 2008 and Misappeal number 4 of 2008. which was taken up for adjudication before the learned district judge, Dhubri. District Judge Dhuri or Civil Judge Dhuri? District Judge Dhuri. Stop. Next, therefore, comma. One attempt is required to be made to call for the records of the said Miss Appeal number 4 of, sorry, 3 of 2008, as well as Miss Appeal number 4 of 2008. Which were disposed of by order dated 16/6/2008. Next para, the registry shall send a requisition by email to the Court of London District Judge Dhubri for sending the scanned copy of the record and order sheet of Miss Appeal number 3 of 2008 and 4 of 2008. Disposed of by order dated 16/6/2008 by email for being placed before the court.
Record will reflect, FAO 46 was disposed of on 23/5/05. And FAO 54 was disposed of on 19/1/06. Also different that was disposed of by the control. Out of these,
No, we are not writing FAO because they will not be able to track out like that. When they have registered Miss Appeal 4, they will track out Miss Appeal 3 and 4. If I say something more, they will not be able to track out. List on 24/1/2024. We will just add one line. If as the records are old records, comma, it is made clear that if for some reason the records cannot be traced out and placed before the court, comma, the court shall make an endeavor to hear the matter on merit. Dasji. এটা বেলেগকে জাজমেন্ট বেলেগকে করে দেবো নাও। Yes. Because if the records come, we'll have to fixing it for hearing in a day or two. Because if we go through the records, if it is available, or it may not be available, we don't know. After that, we fix it for hearing. It'll be a short day after that. Yes, item 2.
Cases, the senior counsel KK Mondosar is lived in Natal and Brigadiers has gone to deliver due to illness of his mother.
You see, 2009 matters we are not adjourning.
So, Ambedkar actually his mother illness last night urgently has gone to Dibrugarh and any date in the first week of January. He will reach for any date of
You
first.
see, it's very difficult to adjourn it because these are placed from the orders of the Honorable Chief Justice.
He is ready to move, but urgently is the illness of mother only. He has gone to Dibrugarh.
Heard this matter at length once before, and a very short question was involved regarding registration of.
No, the question is, you see, it's not a question of entering into the merit. Now we are first dealing with the prayer for adjournment. We don't know, we don't remember it. If I keep recording everything in my mind, I would myself be hospitalized in a day or two. Correct. I don't keep anything in my mind. No dead bodies here in the mind. Because every time the matter is listed, somebody takes an adjournment.
Immediate from first week of the January.
No, but you see, how long it can be adjourned? There may be other emergencies, but every time you see the order sheet. 2019 onwards, 1, 2, about 7, 8, 9, 10 times. How long will adjourn the matter? Conveniently, none of the lawyers appear in certain days. We fix it on Thursday. If nobody comes, then we will make it clear, no adjournment. Whatever be the reason, somebody has to do it. Both sides are duly represented. Mr.
Coming. He has come from Dibrugarh tomorrow.
We don't know. You do it, be prepared. You're not adjourning it.
Please, we are coming from 2nd or 3rd January.
No. Then we reserve it. We will pass a judgment. You file a written argument. You file a written argument. The hearing is closed. Because we won't permit that. 22nd. 22nd of? 22nd of December, this last day. No, last day is not possible.
So, my lord, actually, matter is.
No, we don't know. We've given you an opportunity, but we fix it in the, we are reserving it for judgment. We'll permit you to file a written argument on 2nd of, 3rd of, it appears on 3rd of January. You file a written note.
But Hamlet, we are actually is this. case
No,
is-
I am not adjourning it. I am closing the hearing. Both of you file your written note of argument, exchange the notes and file it on 3rd of January. Because we can't keep on adjourning matters, and these are specially ordered by the Honorable Chief Justice.
Yes, I understand, that, but unfortunately, the mother is badly injured, then that's why he's gone to the degree course.
No, it's okay. You see, we are now permitting you. You file a written note of argument.
Actually, my Indian instructor, me actually, therefore, it's on 3rd of January or 2nd of January, it will be possible. Otherwise, he's come from Dibrugarh 21st, and he will be reached Guwahati 22 of second. He will be ready for 22nd of December. Otherwise, matter fix on 3rd of January or 2nd of January, 4th of January, no problem. It's a 12-hour journey distance from Dibrugarh to Guwahati. 21st is come and early morning 22 is reached Guwahati.
Okay, make it 4th of January. It is made clear that on 4th of January, the matter would not be adjourned at any cost. Also, it is also provided that in the event any prayer for, if the counsel for the both sides are not inclined to do the hearing on 4/1/2023, they will positively file the written note of argument, failing which the matter would be closed and the matter would be decided without the assistance of the learned counsel seeking adjournment. Full stop. Next para. Okay. Yes. Parted. You file an application, file an interrogatory application to have it parted. Will pass orders.
Early.
Correct. If I have not heard and you want it to be kept at parted, you file an interrogatory application, we will file an order. You think we have a lot of time for these discussions? You think we have time? Please understand the value of time. If I have not heard it, why should I keep it parted? You file an interrogatory application. I'm not in a jolly mood now. Correct?
Must have.
My senior expired in the year 2000. I have no brief also to do. I just now I show my name in the public expired. Any issue notice to the because I have no brief in spite of my balance.
Yes. You read rule 65 to 68 of the High Court Rules, Chapter 5. You'll come to know. You just be here, we'll see. This is because Mrs. Chaudhary, I hardly find any ground to sustain the challenge. There are two substantive questions of law. First is the non-consideration of the provisions of 110. And second is that admissibility of the documents admitted without any objection. These are the two issues only. Uh, uh,
There is a suit and there is a counter claim, Lordship.
yes,
Suit decree, Lordship, counter claim, dismissed, Lordship. But there.
you are the plaintiffs. You claim that you are the owner of the land and you are in possession of the land.
On the basis of registered sale.
Sold it and you claim that you are in possession of the land. And now you, in the second appeal, you are trying to take a stand that if the owner is denying that or your ownership, it is the burden on him to prove it. But section 110 is different. Please read 110 of the Evidence Act.
Certified copy of the sale deeds were reduced by the plaintiff in the law court as an exhibited version. Fact, Lordship, today morning I talked with him and came to know that originals are lying with him, Lordship. Never no one advised me to produce those documents, he said, Lordship. That is apart from this record, Your Lordship. And one thing, Lordship, the counter claim was dismissed and first appellate court modified the decree saying that suit is dismissed. Against that, we have preferred one appeal. There is no appeal by the defendants against their dismissal of the counter claim, Lordship. And there is Amir Commission report also I have gone through, Lordship. It shows that our possession is there, Lordship. Only the certified copy of the documents, registered sale deeds were exhibited by the plaintiff.
That is the issue, because that's why I said that you be here. Because I'm frankly not satisfied. You see, the question is that if a document is not per se admissible, unless you lead the what you call evidence with regard to the production of secondary evidence, then that document, even if it is admitted without objection, would not be admissible.
Presumption with regard to registered document, Lordship, there is several.
No, that presumption will come only if you see 61, what does it say? 61 and 63 implies that the proof should be in original. Proof of contents of the document may be proved either by primary or secondary evidence. 62 says primary evidence, what is what. Then comes secondary evidence. So therefore, once the foundation of secondary evidence is laid down, which is then only section 65 can be invoked, and then the evidence can be led to that effect. So if that precondition is not there, the Evidence Act says that the evidence should be the primary document.
Secondly, evidences where the exhibits were not proved, Lordship, as per the first appellate judgment.
Correct.
Were not. But in this case, PW 1 and 2 were adduced. They were not cross-examined by the defendants, Lordship. So thereafter, the plaintiff did not deduce any further evidence, Lordship.
No, you see, please come to CPC Order 18 Rule 4 Proviso.
Recording of evidence, Lordship.
Rule 4 Proviso.
Provided that where documents are filed and the parties rely upon the documents, the proof and admissibility of such documents which are filed along with affidavit shall be subject to the orders of the court.
So because merely filing of the document itself does not create an evidence, that is always subject to the orders of the court, and the order, and the trial stage, the court rejected it. Sorry, the appellate stage, the court rejected it. That the document is not admissible. Now, you have to demonstrate that.
I respect lordship, there are some judgment that admissibility and when it can be raised and when it can be lordship reduced by the plaintiff lordship. But certified, registered deed lordship. Presumption could be lordship taken.
No, this, you see, everything will fall in place only when you can, you could have shown that the primary evidence could not be adduced. And then therefore secondary evidence is something which the court permits you. And then you introduce, then we have the presumption. But you see, when the document, in this case, there was a counterclaim. And the prayer in the counterclaim,
Declaration of those sale goods to be illegal lordship.
to be banned, to be illegal. So you see, for that, these signatures and all, everything, they were required to be proved otherwise. See, for secondary evidence is led in the existence of a counterclaim. Kindly also consider this illustration G of section 114.
That evidence which could be and is not produced, if produced, be unfavorable to the person we withhold say.
Because you see, there's a divide line after 2002, post Salem Advocates Bar Association case. Prior to that, you will get judgments where it says that if the document is admitted into evidence without any objection, the same becomes a part of the evidence. But after 2000, the Salem Advocate Bar Association 2005, the situation is altered because now 18 Rule 4 proviso has come in. So minor document being filed along with the affidavit, evidence on affidavit, is always made subject to the orders of the court. And so far as you are concerned, the worst situation is because it has been held by various authorities saying that an appeal is an extension of the suit. So therefore, you see this order 18 Rule 4 proviso also permits the appellate court to pass an order which is something which is empowered under 105 of the CPC, where the court can pass any what do you call that, any order, whether there is challenge or not. No, it's not only a ground, but it also empowers the court to what do you call to examine that.
For the order sheet, why the 35 copy of the documents were reduced? In fact, we have find one explication in my file that they prayed for examining the official witness and register of Kanongo and all. Whether any order was passed on those documents.
I'm sending it to you. Yes. Dasji. We'll take it after some time. Just wait for some time.
On Thursday, she was the first item. By that time, she can also have a photostat copy of the appeal memo from, and I will go through the records, Lordship.
You can provide it to her, photocopy. Okay,
Today, your Lordship may allow me to go through the
okay. Record sabo karna. Record sabo dibo ito. Okay. Let us see, we overcome this, this question which we have put to Mrs. Chaudhary, and then we'll examine that. No, that's okay, but we can't do it. That's why I said that please go through 65 to 68 of the High Court Rules, Chapter 5. It doesn't permit us to issue a notice.
Wait.
Day after tomorrow. This Mrs. R. Chaudhary and Ms. J. Paul for the appellant. The respondent, the learned counsel for the appellant seeks time to go through the LCR and address the court. So matter stands adjourned today, list on day after tomorrow. Friday, no. Friday I'm going early. I'll sit in 10:15. I'll sit in 10:15, 10:30. I plan to walk out. No, let us see. Let her overcome the first burden.
Item 5.
But in this case, Mr. Avarli will appear in another court. But after some.
After some time, okay. Okay, item 6.
Time.
Time. First of this, today is the third date of continuous default on part of the appellant to be present in court. First of, the appellant was unrepresented when the matter was listed on 10/11/2023 and on 20/11/2023. And today, when the matter is called, the appellant remains unrepresented. First of, accordingly, the court is of the considered opinion that accordingly, it is presumed that the appellant is not interested to pursue this matter, and accordingly, this appeal stands dismissed for non-prosecution. Let non-prosecution.
7.
After some time, madam, my senior is on next.
After some time, just tell him, Mr. Roy, sorry, how much time?
Probably here by 2.
By 2.
Right.
You look very worried. Anything? You're not well. Oh, you're not. Okay. It gives you a very tired feeling, a tired look. Yes, item 8. Yes. You can deposit 50%. You're there to, okay. Let me see, appeal, Mr. AJ Saikia, counsel for the appellant, and Mr. A Lal, learned counsel for the respondent number one. Here for one? Only one or some? Only one, okay. Now, respondent number one, public claimant. Appeal admit, notice steps within 2 days on respondent numbers 2 and 3 by registered post with AD. Postal receipt track report. List also and so, give a date for appearance after 6 weeks. And stay application, stay subject to deposit of 50% of the awarded sum before the registry of the court within a period of 6 weeks from today. It is made clear that if deposit is not made within the time allowed, this order shall not be a bar for enforcement of the award. Next para, on such, on the 50% of awards sum being deposited, the court permits the opposite party number one, public claimant, to withdraw the said amount on being identified by a learned counsel. First of the learned counsel for the opposite party number one shall provide the bank details to the registry to enable the court to transfer, the registry to transfer the amount to the bank account of the opposite party number one. The application disposed of. We are disposing of this application. No, they'll take some time because these are holidays coming. They'll. No, you see, there are holidays coming. There are 2 vacations in between.
9th February. I disposed of.
I had disposed of. Yes, 9.
But the implement order and the judgment is appearing at page number 50 to 70, my lord. Whereby you part. in the
Next,
judgment, but the
next time you instruct your counsel to also give synopsis, because without synopsis I can't read. I find it very difficult to go through the order, try to understand.
if that's-
This is the second appeal.
Yes, madam.
Oh, it's a second appeal, synopsis is not required. Okay, I'm sorry. I thought this is an appeal. It's okay. Second appeal not required. I'm wrong.
Then even if required, we can.
No, it would be not required. I was thinking about civil revision.
My lord,
Yes, you are the plaintiff or the defendant?
I was the defendant, my lord. My and my brother were the defendants. And my sister had filed the suit, my lord. And the trial court judgment is appearing at page number 31 to 44, my lord, whereby the suit was dismissed.
Yes. Just a moment. Yes.
The operative part of the judgment passed by the learned trial court, my lord, that page number 43. Because six issues were, issue number A to H was the issue framed by
In the trial court, what had happened?
the trial court, my lord, the suit was dismissed.
Appellate court reversed it.
Appellate court has not totally reversed, my lord, but has made a conditional order that she needs to get partition first as per the title, and only thereafter that partition can be done. That part, my lord, your lordship will please to see at page number
Page,
I mean, the trial court judgment, my lord, page number 43 operating.
no, that appellate court, that observation.
Appellate court, my lord, is from page number 50 to 70. I am taking your lordship to the page number 70. 70 is the operative part, my lord. It is starting from 69. Page number 69, my lord. In the result, the appeal of the appellant plaintiff is partly allowed with cost. The impugned judgment and order dated 21/10/2022 passed by the London Municipal number 1 Morigao, Assam entitled suit number 2 of 2015 is set aside. Only to the extent whereby the learned trial court held that the appellant plaintiff has no right, title, and interest over the land described in Schedule B to the plain. I hold that the appellant plaintiff has right, title, and interest over the land described in the Schedule B to the plan. However, she is not entitled to recovery of the same as the suit land is yet to be partitioned by inmates and bounds among all the heirs of the late December 12. Prepare a decree accordingly, then send by the recorders.
See, in this entire order, there is only one error.
Appellate court.
The error, as you pointed out, it should have been she has got right title interest in respect of land described in Schedule B to the extent of her share.
To the extent of her share, my lord, correct.
If that was there, you couldn't have been
I
aggrieved.
could not have come before the election.
No, but she's already projected in the plaint that out of this land, Schedule B land belongs to her.
My lord, that is, in fact, no doubt it's a wrong projection. If I can take your lordship, para number 5 and 9.
5 and 9 of
Yeah. The father of the plaintiff obtained 17 lakhs of land. No, of the plant, my lord, page number 21, my lord.
yes.
Page number 21, I can take
Yes.
lordship to that para number 4 because.
Yes,
this is
yes.
also- That while the original Pattatars were alive, they mutually partitioned the shoot Patta land in 4 shares. And as per said partition, Khatra Mohan obtained his share at the northern part of the entire 1 bigha 2 lisha of land, and his south obtained the share of Bisambar Tiwari, and at the south of Bisambar Tiwari obtained the share of Ram Naresh Tiwari, and at the south of Ram Naresh Tiwari obtained the share of Jivtan Tiwari, and in the said way, each of them possessing their respective share of the land of the shoot Patta. It may be mentioned here that in the shoot Patta, the share of the plaintiff's father is 17 lecha. That is not made anywhere as scheduled by. Schedule A contains one kattha, 1 bigha 2 kattha, there is no schedules containing any land pertaining to or measuring 70 Lacha, my lord, pertaining to the same Dagan Patta. Now then, my lord, that the father of the plaintiff obtained 17 Lacha of land as mentioned in the Schedule A of the plan as his share and was peacefully purchasing his share by constructing temporary houses thereon. The father of the plaintiff died about 32 years ago, leaving behind him three sons, namely Shri Hiralal Tiwari, Nirmal Tiwari since Brigis, Shri Raju Tiwari, and three daughters, namely Srimati Kamli Tiwari, Srimati Munia Tiwari, plaintiff, and Srimati Karavati Tiwari, and all the daughters were being given marriage by the father of the plaintiff, and except plaintiff, other sister of the plaintiff has been living with their respective husband houses mentioned in the plan. Then, my lord, paras 6 and 7 are also two paras are important, that after the death of the plaintiff's father, the land measuring 17 Lacha out of 1 bigha 2 Lacha was mutually partitioned among the legal heirs of the deceased Sambar Tiwari, and as per the said partition, each legal heirs obtained 3.5 Lacha of land, and each of the legal heirs of deceased Sambar Tiwari on 11/2/2009 swear an affidavit before the Indeswar Rajbangshi Notary Morigaon by the surviving legal heirs of the deceased Sambar Tiwari with a condition that the case of in case of sale of any share of land Sambar Tiwari by his any legal heirs must be sold to his legal heirs only on the failure to purchase by the legal heirs, the deceased Sambar Tiwari may be sell to any other person. That on mutual partition of 17 Lacha of land belonging to Sambar Tiwari into 5 equal shares among the legal heirs, the northern portion, a plot of land measuring 3 Lacha and 3.5 Lacha of land has fallen in the share of the plaintiff Srimati Munia Tiwari, after her second portion has fallen in the share of Srimati Kamli Tiwari. Third portion has fallen in the share of Srimati Kalavati Tiwari. Fourth portion fallen in the share of Shri Hiralal Tiwari. And fifth portion has fallen in the share of Raju Tiwari. And has been purchasing their share peacefully without any disturb from any corner. But there was no such partition, my lord. Share is there, no doubt. Partition was not there. Now, my lord, this para number 8, that thereafter on 1/8/2014 at about 9 AM, they are meeting in the legal heirs about construction of RCC building at the shoot share land. And in the said meeting among the legal heirs is Sambar Tiwari made a proposal that after construction of building, each legal heirs will get each share as purchased earlier. Subsequently, on 1/10/2014 at 10 AM, the principal defendant number 1, Hiralal Tiwari, and the principal defendant number 2, Raju Tiwari, both jointly occupied the Schedule B land of the plaintiff and started to construct one 2-storied RCC building thereon for business purpose, including the share of the plaintiff. And on demand of the plaintiff room, the principal defendant number 1 and 2 declined to give the room of the plaintiff, and hence the plaintiff is compelled to institute the present suit against that defendant. Loan was taken, my lord. Permission was given, accorded. Loan was taken. Building was constructed. My lord, it is totally impossible as today that a room out of that, when the loan, unless the loan is clear, and unless, my lord, the property is partitioned amongst all in respect of the constructed portion, not the land, my lord, because it has always been occupied by the house. And so far, the taking of loan and the proof of taking of loan, my lord, she also admits about that.
No, that's okay. We not be bothered by that because of prayer number 2 in the plaint. It says to demolish all the existing structure.
Yes, yes. When she has allowed, my lord, she has allowed to construct the building, that too after taking of the loan. But she has prayed for demolition of the building, entire building.
No, but you see, if she has allowed, that means you admit that her share is there. She's
Her
entitled to
share is
some,
there, my lord.
she is entitled to some part of the property.
Some part of the property that she will get only after partition, my lord.
After partition,
Yes,
to your sister.
my sister is entitled to a room, no doubt. But which room she will be entitled for unless she clears the loan amount, because loan is taken from the bank, my lord, 24 lakhs.
Acha. So let
And
me
for
assume,
that-
let me assume, supposing X goes to bank and purchases takes a loan to purchase a land. He takes a loan to construct the house. He will not be allowed to enter the room just because loan is not clear.
No, I'm not on that.
Huh.
What I am on, my lord, as per her consent, as per the meeting held in the year 2014, she surrendered that part in favor of the two brothers for the purpose of construction of the building. Now. in
Surrender
order
the
to-
title, surrender her title.
Sir, no, not the title. Possession, my lord. Not the title. Possession was given
Correct.
because 3.5 lakhs is an integral part of 17 lakhs, my lord. So over 17 lakhs of land, the house is required to be constructed, and for that she has already consented. Now, after taking loan, my lord, she is claiming only a portion of that without paying anything to the bank or without sharing it to the brothers.
Correct. That is the concept I know. You see, you have a big plot of land. We can't underestimate you. You have a large plot of land in the heart of the town, and you give it to a builder. Builder constructs it, and you are entitled to say 5 flats in that. The land itself is a contribution. Her 1/3 share of land itself is a contribution. Why your brother should deny to the sister that lawful position?
My lord, we have never denied the right of my sister to the tune of 3.5 lakhs in the land. That land which she ought to have purchased separately, she has given us the right to construct over inclusive of.
So that is a
plot of land.
contribution.
Yes,
That is a contribution.
the land is contributed, but the money which I have taken from the bank, she is unable to contribute to that, not contributing to that.
No, where is the requirement? That's what I'm asking you. I'm giving you an example. A builder takes your land, constructs a building,
Hello.
and agrees to give you something in lieu of that land.
True, my lord.
So you've taken some part of her land. What are you giving to her in return?
My lord, the example which your lordship has cited, there no loan or no debt is falling into the share of anyone. But here
Yes,
is
a
the
builder
case
will
of-
take a loan.
But here is no, she has consented to take the loan, my lord.
That's it, what?
So
Even
when she
in
has
any construction agreement, there is a consent from the owner to for him to take a loan. The question is that after taking loan, will he demand contribution from the landlord saying that no, apart from contribution of land, I have taken a loan with your consent and therefore pay me the bank loan amount. It's something which is
Not the entire, only to her share, she is bound to pay, my lord, because as per her consent I have taken. Otherwise, if you would not have consented, my lord, then I would have left in one corner her land and could have just, constructed the building.
you see, come to this written statement which you have
my lord.
filed.
Written statement, my lord, is very poor,
Then
very, very poor,
that's why I'm asking you those questions.
very, very poor, my lord.
No, but how, you see, you can't build up a story without there being a pleading in the in that because a share is otherwise admitted. She is claiming that a definite share,
Yes,
and then you see. Instead of that denial, what you say in paragraph 5, the
yes.
schedule A and B land cannot be claimed in the court by the plaintiff as their
As their mens are not in
means actually
Patta.
it should be names. Names are not in Pata.
Patta. Moreover,
Moreover, without partition, the plaintiff cannot point out any land or Pata as a share.
Yes.
So the rest of the things that you have taken a loan that she is required to contribute, those are not even your case. If that is not there, then what do you call this? It
My
will
lord,
amount to
that is there in exhibit 3, which she has produced before the court.
what is exhibit 3?
Yeah, which she has produced before the court and that.
Exhibit 3 is the affidavit.
Yes,
You have a copy of that?
That is page number 44. Yes, my lord,
Page
we have
number?
submitted that copy to the bank also, but the photocopy is there with us.
Shows that.
Your worship will be pleased to see that at page number 44 about that affidavit, exhibit 3, which she has.
No, that is there. I'm looking at that.
Required to be translated then.
This doesn't take you anywhere. It doesn't take you anywhere.
My lord, if that is marked as exhibit 3, then that is the only document which she has submitted with regard to the taking of loan. And
So you
it
see,
not
this declaration is only a proof that she is one of the co-sharers of that land. Correct. Now, where is the description of land?
that description, plan. Planning 17, let shall not be there. It is the mutual. My lord, what I will do, I will take the certified copy of exhibit 3.
No, it's not required. You see, here also, Amar Hakurur Pita is also the Tewari Namat. This is what I can't read.
That's what I am saying, my lord. Exhibit
Uh,
3, we will take the certified copy and then we can.
Jagi Road Town, Kisamat size 444 number, Miadi Pata, 865 number Dagor, Mati আছে আর উক্ত মাটির দোকানের ভাড়া দোকান ভাড়া আছে আমার পিতার মৃত্যু হোৱাত উক্ত সকলো উত্তৰাধিকাৰী আমি হওঁ এই কথা সত্য বৰ্তমান উক্ত মাটিৰ বিল্ডিং ভাড়া দিয়া আমাৰ 3-4-5 নম্বৰ শপতধাৰীয়ে কোনো ধৰণৰ উক্ত আপত্তি নকৰে আৰু আগলৈকে আপত্তি নকৰে বা নকৰা so and so. So it's only for the construction, there nobody will object, correct?
Yes.
If you agree to this, there is no clause there that on construction you will have to pay for that construction. That agreement is not there.
Everyone is required to pay, my lord, all the 5 years. The bank loan.
No, I don't know, you see. This is something which can't be presumed. I took my what you call friend to the shop. Correct. I purchased a shirt and my friend liked one. We purchased both of them. I gave it one to him. So there's no presumption that when we were purchasing the shirts, there was an agreement and meeting of mine that he would pay his share, I would pay mine, because then I know I would be saddled with hundreds of rupees from you also, because in the canteen we had to eat together when I was a lawyer. At times I paid for it, at times you paid for the tea, and we don't know if I was required to share for that.
My lord, your lordship perhaps has not come to that time in situation where all the fives bill given or 20 taka, 2 rupees, 2 rupees.
I don't know, because you see, those are all permutations and combinations. We can't presume that the intention of the parties is to collect money and then make a construction, because there is something which can't be presumed. So she has a share, you give it to her. That has been admitted.
I can assure your lordship that she is entitled to the share and we are going to give, we will give. But my lord, in the IA, we have taken, in the IA application.
Then we'll have to dismiss your, find a ground and dismiss your second appeal,
No,
so
no,
that
my lord.
you give it to her.
My lord, let her come before your lordship and let her say she is going to say on the 20 lakhs rupees out of 26 lakhs taken by the Assam Grameen Bank, and that construction is made for and on behalf of all.
No, her intention is clear. She is asking to demolish the houses. So,
My lord, after giving the consent for construction of the house, she is to stop. The stopper will come upon her.
no, that we don't know, but her intention is very clear. But you can't force your sister to give it when there is no agreement to make payment. That will be her, what you call, that will be her contribution. Otherwise, you may not be able to build a house.
House is already built by.
No, without that contribution, you could not have built the house. So we don't.
And she has nothing given from her side so as to say contribution, my lord. Every money was taken from the bank on the basis of these documents. She has exhibited also.
We can't accept that in the second appellate stage. The reason being, you come to that page 44, which you have showed us. The bank loan component itself is not a exhibit here. So therefore, what terms and conditions you took a loan, whether she was a borrower, she was a guarantor. If you see, it's very simple. If she's a borrower and a guarantor, then the bank will take that part of the property from her. How you are bothered?
She was not the guarantor. Not the guarantor.
So that's why you see.
She has said that she had permitted us to, I mean, by way of affidavit, she has permitted us to construct the building.
So you see that
Her
that
share
itself is not demonstrated. If she is not the borrower, she's got no liability to
My
pay
lord-
for the bank.
My lord, in fact, there are 2 affidavits. I don't know whether this affidavit is the replica of exhibit 3. Exhibit 3. Kindly give me a chance, my lord, to produce that certified copy from the, I mean.
No, certification of not required. Only 2 words in this I couldn't read, but otherwise it's readable. This is the thing. You don't need a certified
So
copy in
because
fact.
she has bestowed her, I mean, right, my lord, upon the brothers.
For construction, she's not objecting. But after construction, she said now demolish it.
Yes.
Correct.
When the construction was made in the year 2014, my lord, now she has come forward and saying that.
You see, Mrs. Sir, there's something which is not there. So therefore, you see, in the second appellate judgment, the infirmity is not there because you see, once you are referring to exhibit 3, then the share of the father is admitted. She is a legatee of the father and therefore her share is admitted.
Yeah, not 1/2 lecha, my lord.
No,
But
she's
only
saying 3.5 lecha.
So 17 lecha to the father.
She's
And
only
then-
claiming 3.5 lecha.
and 3.5 lecha, yes.
3.5 lecha would not be 144 into 3 is 532 plus plus 72. It's only 600 square feet she's wanting.
My lord, no, my lord, kindly peruse page number 25.
25.
25, schedule B which she is claiming.
Plot of land measuring 3.5 lecha out of 1 bigha so and so.
1 bigha, no, out of 1 bigha 2 lecha. But my father's share, our father's share was only 17.5,
You are how many people?
5, my lord,
5.
5.
So 17.5 lecha divided by 3 is how much?
3.5 lecha, my lord.
3.5 lecha. So she's wanting only that.
She is wanting only that, but she has already given that, my lord, vacant plot of land to us for the purpose of construction.
She's not transferred the title.
No, of course not.
So therefore she has a right. And therefore we don't find infirmity in the for second appellate
Right
judgment,
we are not
first
denying,
appellate judgment.
my lord, the right of my sister I am not denying. Per capita right she is having and it is there. But my lord, when she has executed an affidavit and based upon that we have taken the loan, my lord.
No, that we don't know. If there's no pleading, I can't read that.
Yep.
I can't hear that.
This pleading, it is not there. That's why I have said that, my lord, so far this WS is concerned, it is very,
No, it is appropriate. It's now Mr. Satar is building on the
no,
case.
but your lordship kindly see that.
No, you
paragraph.
see, the defendants have not come and said that, no, this pleading was incorrect. I disown that. That's not the stand. So therefore, we'll have to take it that it was an appropriate written statement filed, appropriate defense taken, appropriately contested in the trial court and first appeal.
Why I am saying, my lord, because of that paragraph number 5, which your lordship has already read at
Yes.
page number 29, that the schedule A and B cannot be claimed in the court by the plaintiff as neither named, it will be not man's names are not in patta. Moreover, without partition, the plaintiff cannot pointed out any land of this patta as their share. As her share.
No, Mr. Satar, you are not convinced. We take it up tomorrow. In the meantime, you speak to them. If they are ready to, what do you call?
My lord, after this short vacation.
Okay. Because if they come to a arrangement, that's good enough because on merit,
Yes, yes.
I am against you for the time being. On the prayer made by Mr. A. Satal and the counsel for the appellant, list on. We'll take it up on,
My lord,
we'll date.
either 4th, 5th, 4th or 5th.
Fourth, we are reserving, make it fifth. Fifth. Continue at 2.
Find in page 14 that I have annexed here. That's been registered FC urgency case number 1.
You come to that application for calling for that witness.
Yes.
That is the issue.
That is the issue.
Hmm.
That is the issue, my lord. And it's been rejected, my lord. Because court fee and my lord that nowhere on record it has been stated with regard to the appropriate fines. And after this order has been passed, my lord, before this one, a KV2 has also been filed by them, my lord. And at the time of
moving this petition, the applicant was heard and thereafter the order, interim order was passed. And interestingly, my lord, on that particular month itself, my lord, Principal Judge Family Court was going on retirement on that particular month itself. On that particular month itself, my lord, the presiding officer was going on retirement. 31 was the retirement.
Yes, I also know my retirement day.
Yes, that's there. I have brought on record because we filed several petitions. One is with regard to this, my lord. And thereafter.
No, because you see, that is something which I am also intrigued. Now, let us say I know my retirement date, correct?
Yes,
So from when I should recuse hearing?
no, that's not the thing I am pointing out.
Hmm.
Now, what I am on, that here is a case wherein, my lord will kindly appreciate. I have filed the guardianship case.
Yes,
I have to prove my case.
yes.
And for that purpose, here in this case, my lord, the list of witness issues and documents, this has been given to go by. And on the first occasion, my lord, we filed the two witness evidence, my lord. But the second witness didn't turn up to the court. So on that 23/6, my lord, we sought leave of the court with regard to filing of the evidence of PW3. In the petition itself, my lord, I take your lordship, my lord, it's been already also been stated that the principal of that particular school wherein the illiterate child has been studying, that we also want to call. And thereafter, the impugn order was passed. May I take your lordship to the record?
Yes,
my lord?
yes.
Page 14, my lord, is the plaint, my lord. I will not trouble this honorable court.
Let's just come to that petition first, then we, if required, we go back to that plaint.
Petition, my lord.
That
That
is-
petition, my lord, will kindly come to my lord. Yeah, that petition has been at page 45. That's dated 3/6/2013, 23. Now, in the third para, we have specifically stated, my lord, the previous state the respondent maintains so and so.
Page 47,
Page 45.
45.
In paragraph 3, my lord, we have stated, my lords, further as per information, respondent number so and so have two so and so, my lord, who is studying in so and so, in class 6 and class 8. The petitioner pays before this honorable to direct the principal Kaziranga so and so with the record to prove the aforesaid facts as PW4. Now, in this petition itself, my lord, in paragraph 2, we have stated, my lord, that PW2 Meenakshi Mahanta Brahma could not adduce her evidence in this instant case. The petitioner filed this petition before the honorable court for allowing her to file evidence of her younger brother, namely so and so Sani Mahanta so and so. And in the prayer person, my lord, it has been only a prayer being made with regard to PW3. Because, my lord, PW1 and 2's evidence were filed together. Now, PW2 didn't turn up. So on that day, we filed this petition, my lord, wherein it's been stated, my lord. And thereafter, my lord, this order comes in at page 47.
Just once you're in page 45.
Yes.
Now you tell us, in this paragraph 3,
Yes.
you have referred to some illegitimate
Yes.
relationship, correct? Now, can you be permitted to lead evidence on the projected illicit relationship without that person being a party to the litigation?
My lord, as per the High Court rules, my lord,
He's required to be added in as a
Yes,
party.
in the
When
High
you
Court
claim
rules.
that there is a illicit relationship,
yes,
if there is a what you call what is that word called? What is that word?
when it's been with regard to adultery or.
Adultery, right? Adultery. Adultery, the person has to be a party.
This is with regard to a matrimonial matters. In the divorce petition, she has been a party. This is with regard to custody of this.
No. The point which I'm trying to make is that supposing X and Y are litigating, correct? Now X says that why is maintaining an illicit adulterous relationship with A?
Right.
Now, can that issue be permitted to be decided in a collateral proceedings without A being a party? Can our presumption as to the finding as to the relationship be recorded by the court in the absence of it? Because I'm showing you something.
In the High Court rules, this is with regard to matrimonial disputes in divorce petitions, my lord, wherein if it's been a adultery or otherwise, my lord, that High Court rules allows, my lord, family court side.
You have the Evidence Act,
Yes, maybe
Section 50.
50, yes. That
Yes.
is with regard to a different altogether, my lord. Wherein.
No, when the court has to form an opinion as
Yes.
to the relationship of one person with another,
Ah.
the opinion expressed by conduct as to the existence of such relationship, or any person who is a member of the family or otherwise has special means of knowledge on the subject is a relevant fact. Provided such opinion shall not be sufficient to prove a marriage in proceedings under the Indian Divorce Act or in prosecution under section so and so.
Yes, so far my understanding with regard to section 50 is concerned, this is with regard to when adultery was a penal provision, my lord, wherein there has been an allegation of adultery. Now, rules of evidence says so, my lord, with regard to this, that section 50, that the first marriage as well as the second marriage is required to be proved in a case of adultery. And in case of the divorce for adultery, my lord, then as per the High Court rules, then that the person against whom allegation has been made, they become a necessary party. But here is a case with regard to guardianship, my lord, with regard to a conduct of the other party, my lord, wherein I have to prove by adducing evidence which is believable and which is based on records. And with regard to that, my lord, I want to adduce the evidence of this particular, my lord, principle, wherein, my lord, in the plaint itself, I have stated that he is having illegitimate children.
Okay.
Because section 50, my lord, at my initial stage of my career, my lord, once in a criminal trial, my senior Jatindra Mohan Chaudhary, my lord, he argued the matter in SDZ. Still I remember. And with regard to that, it was a discharge argument he advanced before the court, and the judicial officer is someone hot at that time. And that was the argument with regard to that. That in a case of bigamy, my lord, and when adultery is being alleged in a criminal matter, the requirement under law, section 50 is to prove both the marriage. Only one marriage is proved is not sufficient. If both the marriages are social marriage, then essential of the social marriage is also required to be. Now, my lord, if your lordship allow me, I'll take one by one, my lord, with regard to the factual matrix of this case. That is my, at page 40, application under section 7 of the Guardianship and Wards Act 1890, my lord. Herein, my lord, at paragraph 10, I have specifically stated with regard to the aforesaid facts, that the petitioner stated she recently came to know that the respondent has elicited so and so name also been given, a resident Betapara so and so so and so. Further, she came to know that the respondent has married the aforesaid lady secretary and they are maintaining so and so in law supported by aforesaid illegal acts of the respondent. The petitioner further came to know that he gifted a BSNL prepaid SIM so and so and a Ford vehicle to so and so and stayed at a flat at Beltala. Then so and so changed her name to Anushka Devi Sharma. Now, this has been at the inception itself, that is my case. And if your lordships comes to my evidence that I have filed in the court of law. Yes. That is at page 78, my lord. Can we come to 70? Evidence on affidavit, my lord. And here, my lord, specifically with regard to copy of the affair and all the affair been lodged through Sevali Basumatari against me, my lord, with regard to dokaiti, robbery and all such things. In paragraph 9 is very important as well. That the respondent has illicit relation with one so and so resident of so and so. Further, I came to know that the respondent has married the aforesaid lady secretly, and they are maintaining their illicit relation, and the mother-in-law supported the aforesaid illegal acts of the respondent. I also came to know that he gifted BSNL so-and-so, 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 and a Ford vehicle to Sehwali Basumatre and stayed in a flat situated in Beltala. That Srimati Sehwali Basumatre changed her name to Anushka Devi Sharma. Further, I recently came to know that the respondent and the said Sehwali have two so-and-so, 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 my lord, studying in school address, everything I have given. And evidence of PW3, my lord, I have annexed that one also, my lord. And evidence of PW3 also speaks the same way. That is at page 135.
Page
135, my lord. PW3 is the evidence, my lord. And in paragraph, relevant paragraph with regard to these facts, my lord, is paragraph 9 at page 137. Paragraph 9 and 11, starting in Kaziranga school, so and so. We wanted to call this principal of this along with records. That's all we wanted to do. Para 9 and 11. First, we stated in there. And in paragraph 138 page, my lord, paragraph 14, the respondent is a criminal-minded person and accounts maintaining so and so, so and so, so and so, so and so is affecting mental health of the minor child. That is also there. Now, my lord, will kindly come to page 36 once more. This is with regard to, my lord, when after the guardianship case was preferred, my lord, being a responsible mother, my lord, what was my stand? That is the last line, my lord.
just a moment.
Yes.
Yes, which page?
36, my lord. That is the order dated 25/2/2019 after their filing of their written statement and a counter claim. I am reading it, my lord, that order. Heard both the sides on petition number filed by the opposite party praying for visitation right of the minor sign so and so. It has submitted the child is staying in the hostel so and so, Bongaigaon. They have raised no objection and submitted that the opposite party may visit the minor child in her presence only. According to the prayer of visitation is allowed on the first 3 Sundays on every month in so and so school medium as per convenience of both the parties. Accordingly, prayer for visiting rights is allowed as above. Seen petition number so and so filed by the opposite praying to allow him to meet his son on 2/3/2019 to celebrate his birthday of the minor child. Heard both sides. Petitioner has no objections. I didn't have any objection with regard to his visitation rights also. But as because she apprehends with regard to his, my lord, uneven behavior. She is apprehensive about it, and so at her presence, he can meet his own minor son. There is no objection as such. Now, an incident that took place, my lord, when the minor's son was in Bongaigaon, my lord, and thereafter another petition has been filed, my lord, and that order, my lord, will kindly come to page 41, my lord. The minor son was produced before the court again. Page 41, order dated 2018. Parties are present, minor so-and-so is produced before the court by the so-and-so, 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 statement recorded. The parties are present and the respondent so-and-so, so-and-so file an objection against the petition filed by the petitioner so-and-so, so-and-so. The parties have agreed that the child will be admitted to Royal Global School, Guwahati, and the expenses will be borne by the father. The child will remain with the mother with visitation rights to the father. As per the earlier order, the father will visit the minor child and is at liberty to take him to park in the Science Museum, Khanapara, so-and-so, and spend time from 2 p.m. to 5 p.m. The mother may remain present in a hearing distance of the meeting place without causing any disturbance during the meeting of the son and father. The petitioner father will not extend the meeting time after 5 p.m. So far, the medical checkup of the minor child is concerned, you will be examined in Excel Care Hospital, perceived so-and-so, 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 inform the principal, so-and-so, so-and-so. Now, this has been the order. Now, subsequently, there too are the orders, my lord. I am not taking this honorable court. Now, coming to the petition at page 45, my lord, I have already pointed out the petition, my lord. And all disputes started from here. And this petition was preferred on 3/6/2023. And the next date was fixed on 9/6/2023.
Yes.
On 9/6, my lord, as per the instruction that I have received, witnesses were present. Witness, the PW3 was cross-examined on that day, particular day. And thereafter, my lord, this order was passed. The petition.
Which page?
Page 47. The petitioner, Srimati Poonam Sharma, is present. Opposite party so-and-so is absent in states. Since petition filed for him being petition number 958 showing cause of absence, which is being allowed after it being considered. The evidence of PW3 submitted by the petitioner in respect of Sunny so-and-so is accepted by dated 3/6/2023. The copy of the evidence also furnished to the opposite party. Accordingly, PW3 is present, cross-examined, and discharged. Now, with regard to the earlier petition on 3/6, my lord, Learned Counsel for the petitioner has submitted that the petition being 905 dated 3/6 is pending for hearing on the premises that by this petition, the petitioner is required to be allowed for filing the evidence of her younger brother, namely Sanjay Mahanta, PW3. The opposition, however, has not raised any objection in earlier occasion also. According to the prayer so filed by the petitioner, allowing her younger brother to depose as witness in connection with the case of SPW has already been allowed by order dated 3/6/2023. So the prayer filed by the petition being number 905 of 2023 has been disposed of by allowing PW3 Sunny Mahanta as witness in this case. Now coming to paragraph 3. Now one part he has disposed. He recorded the evidence thereafter this order. Now coming to paragraph 3 of the petition, it appears as per information, the respondent is maintaining illicit relation one Sevali Basumatari and as such no illegitimate children and two so-and-so, so-and-so, so-and-so were born out of the relation of the opposite party and said Sevali Basumatari, both children are studying in so-and-so, so-and-so. As such, the petitioners paid before the honorable to direct the principal Kaziranga so-and-so, so-and-so to appear before the court with the record to prove the aforesaid facts SPW4. I perused the petition so filed by the petitioner under 7 of the Guardianship and Wards Act 1890. Upon perusal of the existing material on record, it appears to me that the petitioner has not ever any of such fact that the opposite party is maintaining an illicit relation with Sevali Basumatari. This is a finding, my lord. And out of their wedlock, my lord, 2 children were born and they are by now studying in so-and-so, so-and-so, Guwahati. In the original petition, not disclosed in the evidence is adduced by her before the court. This is 9-6, my lord. We have adduced our evidence, file on affidavit. After that, this is the finding, my lord. Disclose the evidence adduced by her before the court. Moreover, the prayer preferred by the petitioner is only confined to acceptance of evidence of PW3. The petition is also stamped only ₹2, which reflects only one prayer. So preferring another prayer is in a single stamp petition cannot be entertained. So considering all these aspects, I am of the view the prayer preferred by the petitioner in respect of directing principal so and so has been rejected. The record further goes to show that two witnesses has already been examined and discharged. So the evidence of the petitioner is closed. The opposite party, however, declined to adduce any evidence, so let the case be fixed for argument 23-6. So what I am on the face of this record, my lord, that findings that original petition with regard to Sehwali illicit relation is not been there is contrary to records. Further, from the evidence, it has been reflected in the order that evidence doesn't show with regard to that two children, my lord, studying in this. That is again contrary, my lord. Because their evidence, PW3's evidence as well as PW1 evidence states so on oath. And they were cross-examined. And what I am asking for is a limited, my lord, my case I have to prove in any proceeding, my lord. The minimum thing I am asking is to adduce evidence. Nothing else. If I cannot prove, my lord, that these statements are wrong, that goes against me, my lord. But on oath I have stated with regard to this fact.
What is the other? There are three orders and a challenge.
Yes, my lord.
One is
Three
9-6.
others I have challenged, my lord. These are consequential order, my lord. Then when we came to know about this particular order being passed, now on 23-6, my lord, we filed this petition before the court. We have stated all such things, my lord, in this particular petition, my lord. to
Where is that
allow-
petition? Which page?
Page 15,
660
50.
50.
Now, that in the instant case, certified copy of the last order applied for, and the petitioner came to know that the case has been fixed for argument. Then on 3-6 petition number so and so was preferred by her for allowing her to adduce another witness, namely Sunny Monto. On 3-6, this honorable court was pleased to fix the matter for objection and objection hearing on 9-6. On the petition 905 dated 3-6-2023. That before passing of the order on 9-6-2023, the evidence of petitioner has been examined, cross-examined and discharged. That in the petition 905-36 in paragraph 3 petition mentioned calling of so and so to the fact that the respondent have two so and so. Although the petition stated about the direction of this honorable to call for principal along with the record, but the petition, no prayer has been made in view of the fact that it is only been made after, it will be only be made, it should be, my lord, after the examination of PW3, a prayer is being made to examine PW4. That on receiving the certified copy of the order dated 9-6 and 26, the petition could discover that the petitioner's evidence has been closed, whereas the petitioner evidence is not yet closed and wants to adduce another witness, which is mentioned in the petition dated 3-6-2023. That in paragraph 18 of the guardianship case, the petition specifically stated that the respondent has so and so. Further, in her evidence on all specifically stated the respondent number 2, so and so, illegitimate child with Sehwali Basumatari. Further evidence has been adduced by herself about the illegitimate children of the respondent and about their studying in so and so school. That the petitioner stated that this honorable court by order dated 9-6 was pleased to fix the matter for argument, observing that there's only 2 stamp paper. These are the observations, my lord, that there is no avertment regarding maintaining illicit relation by the opposite party with one so and so, which is contrary to record. In view of the fact in paragraph, I have pointed out. Next paragraph, that the petitioner being a mother of a minor and a housewife, she has no option except this honorable court to pray for the guardianship of the minor who with her since his birth. The respondent is a very influential person and she and her son suffered a lot in the hands of the opposite party. The petitioner stated if the honorable court doesn't allow, will not be able to prove her case and defending herself and to prove the facts of birth of illegitimate children of the respondent as a result of illegitimate with so and so so and so. Now this petition was filed by that. And a prayer was made. by
Where is the order?
Yes, the next, this order is at page, my lord. 59.
No, 59 is fixing a date of hearing.
60, I'm sorry, 66, 7.
60. Okay.
The petitioner so and so is absent. Seen very so and so filed by Anne Moore advocate for on behalf of the petitioner stating the petitioner could not present today as she is suffering from cervical pain, bed rest as informed over telephone. The petitioner is being considered and allowed. The opposite by Kalyan Sharma is present. Seen petition number so and so on behalf of opposite party paying for concerning the absence of the opposite party on the ground that the opposite party is not positioned to appear before the court. The petition is being considered and allowed. Fix passing necessary on the petition 102 and 1024. Hearing relates to a petition already been heard. By filing so and so petition, a petitioner has prayed to Paul, principal of so and so, with records to prove the case of the petitioner that opposite party has two so and so children who are studying in Kaziranga English Academy in class 6 and class 8. Accordingly, the copy of the petition is given to the opposite party for filing objection, if any. The opposite
It's
party
okay,
has-
Mr. Bhuyan, I have read this.
Yes. The next page is important.
No.
See,
I have read it in the meanwhile.
Yes,
What is the third order under challenge? Which
Yes.
page?
that I am coming to that. That third petition, my lord, that is 65 is the petition, my lord, which was filed, my lord, for review of this order, my lord, so that we can adduce evidence. The first order, my lord. 9-6 order for review, this petition was filed on the same facts, my lord, I have stated. Yes, that order I have brought on additional evidence because time was limited, because I have given on record, my lord, 27 orders. This was again the review of the order, minus so that I can adduce again. Page 151. I have brought by way of a additional my lord, affidavit. For review of the 9-6 order. my lord.
That review is registered by order dated at page 72. No, sorry.
Petition is 65, my lord.
No,
And
this
the
petition
order I have
order,
annexed by way of a, my lord,
additional affidavit,
additional affidavit at page 151.
151.
Portion is 152. The petition has been rejected on the ground that I found nothing to revisit the order dated 9-6 and 6-7. Since the matter has already been decided by this court and there is no any material to revisit the order.
Okay.
And fix for my lord, judgment. 28-7 for judgment.
Yes, Mr. Roy Chaudhary.
I make one submission as because query has been made by this honorable court. This is with regard to appendix 13 of the High Court rules, my lord. Hindu marriage.
I'm aware of that.
Yes, so this is with regard to my lord, divorce or judicial separation. In every petition for divorce or judicial, not in custody. And in the divorce petition, she is also a party. Some of the judgments I have brought in, my lord. High Court rules is 8, my lord. in every petition for divorce or judicial separation on the ground that the other spouse respondent is living in adultery or committed adultery with any person. Solemnized of the marriages shall make such adulterers so and so as a co-respondent. Take a look at it.
Yes.
It's been a judgment October 13, 2022, my lord. Here, my lord, 115, my lord, regional jurisdiction that has been discussed, my lord. The High Court was pleased to dismiss the writ petition, my lord, under Article 227 of the Constitution of India. Observing that the writ petition under Article 227 of the Constitution of India is not maintainable, as remedy by of revision under 115 is available to the appellant plaintiff. As observed by this High Court, if so and so judgment has been discussed, my lord. Ultimate, my lord, here in this case, paragraph 5 is very relevant, my lord. The Honorable Supreme Court has stated that in view of the above and for the reasons stated above, the present appeal succeed the impugned judgment and order passed by the High Court dismissing the writ petition under 227 of the Constitution of India on the ground that the same shall not be maintainably hereby granted set aside. The matter is remanded to the High Court to consider the writ petition in accordance with law and on merit for which we have not expressed anything on merit in favor of either petition. Paragraph 4 is also important. Even otherwise, it is required noted that even according to the High Court, the remedy able to the original plaintiff was under section 150 of 15 of CPC. In that view of the matter, High Court ought to have converted the repetition under 227 of the Constitution of India into revision petition under section 115 CPC. Another judgment, my lord, of this honorable court, my lord, Honorable Justice Sama, my lord.
Yes.
Another judgment, my lord. Contemporary target of private limited and others appellant, my lord. This has been a judgment that was pronounced in 93, my lord. The moot position was before the court. That is in paragraph 7, it's been, my lord, mentioned, my lord. The important question of law that arises for determination.
Which paragraph?
7. The important question of that arises for determination in the present case is whether the petition against the applicable order is permissible under Article 227 of the Constitution, with which Article 115 and 151 of the CPC, or to put precisely whether the order passed under Order 39 Rule 1 and 2 of CPC, which is applicable under Order 43 Rule 1, can be challenged under Article 227 of the Constitution, with 151 of the CPC. Now, the submission of council, minor, that has been recorded in paragraph 8, my lord. And 13 is been, my lord, the 14 is the ultimate finding of this honorable court. That after going through the judgment as we talked about, the broad consensus is that extraordinary jurisdiction of the High Court under 227 of the Constitution can be invoked in any case where there is a violation of fundamental basic principle of justice and fair play, or where a patent or flagrant error in the procedure of law has crept in, or where the order passed resulting manifest injustice despite the existing of an alternative legal regime. That's what I'm.
Yes.
Another judgment, 2003 Supreme Court, my lord, SEC 675, my lord. Surya Devi Rai. The relevant paragraph is paragraph 34 and 30.
Surya Dev Rai is overruled.
So these are the two judgments I am relying in, my lord. What I am on, my lord, that in any proceeding, my lord, it is my duty to prove my case. And, uh, and so, my lord, I want to use the evidence in this case, my lord. And without hearing me and without giving me that opportunity, the evidence has been closed. And then the order that has been passed is contrary to records. In view of the fact that in the evidence on record, it has been specifically pleaded case of the plaintiff matter with regard to the aforesaid facts. And as such, my lord, I pray, my lord, by invoking all its power and the authority, my lord, will allow me to adduce evidence as to PW 4, that will call substantive justice to me. And 227, my lord, this honorable court has ample power.
Because in that subsequent judgment, it has been distinguished, 226 would not lie to challenge the orders of the court.
226. But 227 powers is always.
It's a superintendent jurisdiction.
Yes, always there. Wherein ultimately, my lord, the court has to do justice, my lord, between the party and substantive justice, my lord. Not only done, seems to be done. Depriving me from proving my case, my lord, that cannot be the rule of law.
But you have to overcome one more barrier.
My,
Thus, Family Courts Act. Family Courts, say another. Family Courts Act. It will. Okay, not against applicable, sorry, interlocutory orders. Okay, okay. Yes.
Page, in the 24 page, section 7, which that, that actually is regarding the custody and the jurisdiction to the. The suit was at the stage of argument and judgment. In their claim, you will actually find that page. Fine. First of all, I will take your lordship to their main claim of the section 7. Section 7 application, it starts at page 14. And the relevant portion is at page 16. Because the maintainability of this petition, 115, 151, 227. And the 4 orders are under check. One is closing of evidence. One is under order 16, it is the assistance of the court to call for a witness. Another is transfer of a proceeding from one judge to another. Another is a witness. 4 different orders. It cannot be under 127. If I take it to be at 27. One is under closing of evidence, that is 9-6. 9-6 order is closing of evidence. And next order, that is
Yes, just a moment.
9-6-23.
This is for closure of evidence. Yes, second is
6-7-23 under order 16 application. And for transfer of case from one judge to another. 6-7.
yes,
27-23 is a review of the
20.
7-23. The first title says application under section 115, reduce 151, and article 227 of the Constitution. That's the provision. And if I take it to 27, some error here or there, or some legal flaws will not be looked into by this. Only if there is a lack of. That is the recent judgment of 2022, 4 SCC, page 180. Para. 4 SCC, page 181, para 15-16, 15 to 17. Finding of civil court interference with the exercise of power and identity. And my lord, I take your lordship to now page 14, your application. Page 16, para 10. That the petitioner states in their application that she recently came to know that the respondent had illicit relationship with one Srimati Shivani Basumati, a resident of Bhetapara, Mohmara, Guwahati. Further, she came to know that the respondent had married and assisted very secretly. They are maintaining their illicit relationship and father-in-law supported the affected illegal acts of the respondent. Further came to know they gifted BSNL Singha, code and flat and something. Nowhere it has been stated about that college principle or the future. No. This aspect of the matter is silent in this. Regarding the principal of Kajinanga School and the 2 illegitimate child, nowhere it has been mentioned.
Yes,
Moreover, Shivana Basumati, against whom they are alleging that I have illicit relationship, she neither mother made a party, neither she has been called for a She is neither as a witness, she is neither called for a made a part. In both the occasions, Shailesh Basumatari is silent. If the legit relationship is not proved, who's Shailesh Basumatari? What is the outcome of bringing a principal and the two child from that family? And it is quite a belated stage. Quite a belated stage. I am not taking into account Malad on 9/6, that first order which is there under challenge. Malad, that is 9/6/23. 9/6/23, page 47. If I read that paragraph where the knowledge trial court judge has stated that.
No, you don't find it, there's a delay. It was filed on 24/7.
Malad, I am delaying in the suit procedure. Delay in the suit procedure. Why they have not stated anything in the list of witnesses? Malad, if under order 16 rule 1(3), though they have quoted in a different function, order 16 rule 1(3) says, if you want to take the existence of the court other than 1A, as a 1A, every party has a right to call for the witness and to them by themselves. But if they want to take the existence of the court, they have to show reasons. What was their, why they have not filed the list of witnesses during the time of claim. I can witness some judgments on that. Order 16 rule 1A, no 1(3). It is their provisions under order 16 rule 1. It is not 1A. Order 16, and here what is they have stated, my lord. Page 48. What the learned trial court wants to place it on that record is that in the middle portion, may I read it slowly now?
Just a moment.
Page 48. I want to place in Salah, calling of a witness should not be in the routine but a deliberate duty of the court to exclude belated, vexatious and frivolous demand. Order 16 rule 1, summoning of witness. They have to show reason. What was there prohibiting them from giving the list of witness the name of the witness? At page 48, because maybe.
Yes.
On perusal of existing materials on record, it appears to me that the petitioner has not averred any of the such facts. The opposite party is making a illicit relationship with children, and out of the relationship, children were born, and therefore not cardinal English that will be good in such and such. But here it has stated that the principle and nothing has been stated in the frame. It's true, it's a fact. Nothing in the frame has been stated. It is not that only the first portion they will read it. It has to be read as a whole. They have not said anything in the frame. I am showing you also that they have not said about conjuring of school, neither said about the two child. And now, my lord, I take your lordship. This order, the ultimate condition in the page 49, that show the evidence for the petitioner is closed. The PW3 was allowed, and so evidence was closed at page 49. Now their application under order 16 rule 3. It should be 1(3). They have quoted order 16 rule 3. Page 50. Whose name is not in this table. They have to show reasons for at this stage of the suit why they have what they have forbidden from calling that witness or giving the name in the list. Nowhere in the petition, my lord, they have taken. Nowhere in the petition they have taken. Page 50. And my lord, page 55 is their application for transfer. Thereafter,
Page,
their application for transfer. Thereafter, your lordship will. Alleging biases or anything else, my lord, in the thereafter.
yes.
That today on 23/6/23, the honorable court is open court stated, we will dispose of the matter before capital. As the petitioner is an apprehension that should be feasible. And the payer portion, on the aforesaid fact, the transfer of instructors to other. Page 56. And in para 5 also they have stated that considering the above said fact, the petitioner do not want to pursue the instant case before this honorable court, and such file this petition to transfer the instant case to any other court for the age of the. And then at page 59, the order, at page 60, 6/7/20.
Yes.
Your lordship was already gone through, where in the ultimately, court has dealt with and stated that this application was at page, last paragraph of page 60. Accordingly, a copy of the petition is given to the opposing party's file objection. If the opposite party has however filed objection, taking to interview that the petition is not maintainable, since the name of the witness is not listed. Instead, shall consist for hearing argument of an order dated 9/6/20. After closing the evidence of the petitioner followed by declining to adduce evidence for the opposite. No party in the proceeding can be allowed to file a petition with same fair as the which. That is the concept on the order 16 rule 1. I will place the judgment balance. A similar plea raised by the petitioner, white petition, was rejected by the court of Nancy. The petitioner has not challenged the order of this court passed on by dated 9/6/20. So the present petition with same fair by calling the principle cabinet is not warranted. Allowing such fear by the court would amount to review of the judgment. Moreover, the alleged facts of the petitioner by examining the principle has got no relevance to the present case. Hence, the opposite party case for dismissing the. One of the case is illicit relationship with Seoli Bosum. Seoli Bosum, they are not calling Seoli. They are calling a principal or a child from a different school and college, where nowhere it was stated in the petition. And why they have come at this stage to place for that witness, they have not, and why?
It is good that you still have faith that somebody will come and admit adultery.
And at page 63, they have said, the court head, there is no specific provision in law is mentioned in the transfer petition. Obviously, the petition is presumed to be filed under section 24 of the Code of Civil Procedure. Section 24 of CPC deals with jail for a transfer and withdrawal. Subclause 1 says that no application of any party or such a desire to be heard. No issues of the High Court of District that we actually transfers to another. Ultimately, hence of petition, file petition of being seeking transfer of the instances of this court or any other courts can. So this transfer petition was. First of all, my contention, this petition is not maintainable. Seoli Basumatali is not a party as per section 50, and neither she was called for evidence. My lord, order 16, first judgment, my lord, that I want to present this, I have not done. So what you have to do. This 2022-4 SCC, page 181, information of jurisdiction of the High Court, nature and scope, page 181, para 13 to para 15 to 70. Then, my lord, these two judgment, my lord, delay in filing an application witnesses explanation, this has to be given. This has to be given. Two judgment, one is 1995 code SCC, para 3-4, and another 1978, one SCC page 10, para 4.
19,
Color please. Amit color 1995, 4 SCC 244. Delay in finding list of witnesses.
1995,
4 SCC page
page
240.
244.
1978, 1 SCC page 10. In 1995, para is 34. And 1978, 1 SCC page 10, para is 3 to 5. Another page 60, you'll also will get page 60, you'll also will turn to look into one aspect of the
Page
60. I've got one paragraph. By filing the petition number 1020, the petitioner has failed to call the principal Bajranga English Academy Board with request to prove that they are the petition. The opposite party has two eligible children naming a certain site who are studying in Bajranga English Academy for 6 classes. So they are quite grown up. Since the matter and they have got married, in their petition they have stated 2008. So quite a, maybe if they are ultimately they are not a very person. At least 14, 15 years now. And the last matter that is under challenge is of review matter. That is at page 151. Order 47, rule 1, read section 1.
that is at page
151. That is the order of review. Filed by 27, 22. It was in 18, 2 SCC page 87.
2018,
2 SCC page 87. Regarding 227 supervisory jurisdiction of the High Court. There are 12 to 14.
what is the name of the parties? 2018,
Rajkumar Bhatia versus Subhash Chandra. The only cases under 227 is what we have stated in 227 in the 202 22. That now High Court exercising supervision registration of 227 does not act as a court of perspective or to reappreciate, reweigh evidence of facts upon which determination under challenge is based. Supervision jurisdiction is not to correct every error of fact or even a legal flaw. When final finding is justified or can be supported. High Court is not to substitute its own decision on facts and conclusion of that of the inferior court of family. Jurisdiction exercised is in nature of correctional jurisdiction. To state right based jurisdiction of duty of flagrant abuse, violation of fundamental principle of law, power of article physically is exercised primarily in appropriate points. Likewise, there is no evidence at all to justify. The finding is so far that there's no reasonable person can come to a conclusion. According to me, that is the only thing. Not for every here and there small mistake. Lack of jurisdiction has to be. This is my thing. And I raised my thing.
okay, well,
My
Great.
the case that where my friend is saying that they have another child.
One thing I point out, my lord, the guardianship case was filed in 2018 it was filed. And in the meantime, my lord, this development has taken place and information is being given. And it has come on evidence or record. I'm
Uh,
obliged.
Mr. A.K. Bhuyan, and counsel for the petitioner, and Mr. P.K. Roy Suri, and counsel for the respondent. The arguments are concluded. List on 3/2/2023 for delivery of orders.
Deeply obliged.
Yes, Mr. Sayola will take up your matter now.
Think whether it is please today, my lord, outside. Because time is short, my lord, about 1 hour. It's being done. I think 2 hours will be required, my lord.
But the only difficulty is that the three matters which you have already heard. One matter, huh? It's pending for orders.
My lord, the losses, this it on 4th of January, and talk about this, my lord, we shall finish it, my lord. Importantly, we shall finish it. Like first, part for first item.
Okay. Mrs. Jane Sayola, Senior Counsel for the petitioner. Along with his learned instructing counsel, as well as Mr. K.P. Pathak, standing counsel for the Forest Department, are present. So today also for paucity of time, the matter could not be, the hearing could not be commenced. Which is the matter which I have heard. 6603. Next, but it may be mentioned that
I took
this set of three writ petitions were heard together with WPC 6603 5052.
That matter is not disputed because they're also. Six six zero three.
That was 6603. 6605. Ah, 5052. 5052 is completed.
That-
You say it may be mentioned here that this these two writ petitions, i.e. WPC 1357 of 2015 and 6654 of 2022, the three writ petitions are 1357 of 2015 were heard together with WPC 5052 of 2022. First off, while the hearing in WPC 5052 of 2022 was concluded and judgment was reserved, so however, these three writ petitions were released for further hearing, were relisted for further hearing. Yes. As these three writ petitions relates to the relates to limestone.
That was really, that was not hard. Limestone. Limestone was not hard.
No, this relates to limestone.
That's so, regular
And then what was that? 5052 is what?
stone. And these are stone query by the casting machine.
Acha.
Casting.
This relates to stone crushing units. Full stop. Next paragraph, be that as it may. List these three matters on 4/1/2024 in view of the forthcoming winter vacation. Let the records of WPC 5052 or 2022 be tagged along with. Correct? Three writ petitions are there. No, this 5052, 1357, 6554. Only these matters are there. One, two.
Five has already been reserved by the.
Oh, they भूले से. There are three writ petitions. Only 5052 judgment is reserved. Therefore, list these three matters again on 4/4/1/2024 for further hearing in WBC 1357 of 2015 and WBC 6544 of 2022. I'm not saying first item. You make a mention, we'll take it up. This time I'll remember and take it up. We'll take it up at 10:30 then. Just remind me and take it up at 10:30. Like 10:30 be here. Because 10-15 minutes mentioned. At 10:30 we propose to take it up on the day. Just remind me on that day.
যিটো CAV হোৱা বুলি কৈছে কিন্তু আমাৰ CAV লিষ্টখনত থাকিব লাগিব নেকি যিখন
কোনটো?
CAV লিষ্ট বনাই থৈছো
Yes, item 10.
I'm going to file the substitute petition for restaurant number 3, my lord. Who died on 27/9/2023, and I am already informed the appellant about the death of the restaurant number 3 on 79/20. They are collecting the names. If the other side collected punish me the name to the legal heirs, in that case, it will be easier. So within time, my lord, I will file it. They are now appearing also restaurant number 4, restaurant number 3, my lord. You already expired. And your lordship may kindly peruse your lordship's order 19/10/2023.
Now just tell me, you have a brief of second appeal. You have the second appeal brief.
Yes, ma'am.
Who's defendant number 3, page 5, it's a copy of title suit. What is the name of defendant number 3?
It's Darajuddin Ahmed alias Daraj Ali.
No, I am asking you to read the second appeal brief. Who is defendant number 3, page 5?
Darak Ali, my lord. That is
Then, now who is this number 3 in your application?
in my appeal, my lord, Darajuddin Ahmed alias.
No, I
Daraj
don't
Ali.
know whether names can be substituted. That is something I don't know. If the defendant is the Daraj Ali, Daraj, how Daraj Ali can become Darajuddin? name is Darag Ali, D-A-R-A-G, Darag Ali. Your, here, respondent number 3 is Derajuddin Ahmed. alias Deraj. It's totally different name. You take a call.
And they have appeared, my lord, before your lordship.
No, now you are saying this adjournment is what? That number 3 is expired.
Three is expired.
So this is 3.
Three, my lord, for is, my lord, in fact, my lord, Daraduddin or Darag.
Now who died?
May be allowed to substitute, my lord, as well as correct the. It seems, my lord, that appeal was not filed by me also, because I have received in the year 2021, my lord, matter is 2015, my lord. That was filed by another council. And today I just. So my humble prayer before your lordship, I may be allowed to.
You have to file an application because this can't be allowed in a verbal prayer.
To correct.
We
and remove
just-
the respondent number.
We just adjourn it. You take appropriate steps, we just adjourn it.
And for also substitution, my lord, of respondent number 3, my lord.
We just adjourn it. This is T Secular and counsel for the applicant. Has prayed for some more time to take steps. Mr. P.D. Bhuiyan and the counsel for opposite party numbers 1 and 3 to 7 is present. 2-1 to 2-4 also. 2 within bracket 1 and 2 within bracket 4 also. 3 with after 3 you write since deceased. TO2 7. Okay.
Date দিলেন
Kundu?
এইমাত্র হওয়া তো স্যার date
No, I did, yeah, we are not fixing a date after ensuing winter vacation. Pardon me?
After winter
Here, my lord, 24.
After vacation, winter vacation, I'm saying.
item 7 রয় চৌধুরী আনন্দ করেছে কিন্তু আপনি স্যার 3-2 উইথ প্রজেক্ট
3-1.
3-1 হবে না স্যার
3-1.
ফর ডেলিভারি অফ অর্ডার
Plus. The cost is to be single.
হ্যাঁ হয় স্যার মনে দিয়ে দিচ্ছি
Better for a single. I do something. I do. This is 11. Yes.
While we are seeking review of an order passed in revision petition by which this agreement for sale was rescinded with consequential order of restoring back the possession and some other incidental order. Last time, my lord has asked us to prepare a written brief. We have prepared it, my lord.
Yes. Just remind me brief, what is the matter about?
Filed a suit for specific performance of fund.
You are the plaintiff.
I'm the plaintiff.
Yes.
That was rejected. Appellate court allowed it.
Yes.
Then we filed an execution proceeding. In the execution proceedings, my lord, they filed an application under section 28 before the executing court. That application was sent back to the trial court to take it to the original site. Accordingly, it was took up in the original site and dismissed their application, giving us further 30 days time to pay this remaining balance consideration. And that was, my lord, paid within that extended period. Now, against that order, 21/7/2017 order, they preferred this revision. And that was allowed. And this agreement of sale was rescinded. And
You're saying that on the, if it was an application on the original side, appeal would have, that is your contention.
that is one contention. Secondly, we are saying that this is also suffers from want of jurisdiction. Because that 21/7/2017 order was passed on a time bound application. The Section 21 application that a preferred minor was time bound. Now, Section 21, the specific relief act minor, doesn't provide any schedule, time schedule. But there are judgment to show, since there is no time, Article 137 of the
137 would apply.
so it will be 3 years. Now, this appellate decree was passed, my lord, on 30/9/2011, giving us 1 month time. So we have to revisit this balance consideration on or before 30/10/2011. So this right to file this application, my lord, arose on 1/11/2011. And a limitation ends on, my lord, 1/11/2014. And admittedly, this application was preferred sometime in April 2016.
Those dates were not given here.
Dates are not given.
This, in the bottom, there's a space to add those dates here. The direction by the appellate court, the direction under section 28 was sent back to the, for adjudication before the trial court. And that order was passed on
That 21/7/2017.
21/7. 21/7/2017.
17.
Yes, then
Against that, they preferred this revision.
you say the time limit is 3 years.
Application was preferred in April 2016. This 28 application. Appellate court passed the decree on 36/2011. 39/2011, sorry. 30.
11. So you're saying that that application was time barred. Okay.
This 21/7 order is non-est. No legal existence.
Okay. Just add those dates here. Otherwise, I must remember.
My other contention is, my lord, that my lord has exercised revision of jurisdiction and passed certain consequential order, which in effect has the effect of, my lord, modifying the decree. With utmost respect, my lord, perhaps that is not permissible. My lord has invoked the power under 28(2). The impugned judgment order will show. But 28 could be exercised only by the court which passed the decree. Or by an appellate court. Appeal being the continuation of the suit. Not by revision. And thirdly, my lord, there is some factual error there in applicant panel. There is the effect that we failed to deposit this balance consideration even within this extended period.
You had paid.
To this time.
Okay.
That also weighed with the court, my lord, in allowing their application. Basically, these are the three grounds, my lord.
Just write a brief of that 3 grounds at the bottom.
I have mentioned it in page 2 of my
Okay.
challenge.
You pen down the challenge. Okay. Okay.
Page 3, I've given it one by
Okay.
one.
Okay. Just give the dates then. Give the dates then. Okay. Okay. Yes, Mr. Sahu.
It was no time back for me, but it's a time was given to me to deposit. Secondly, we know, yes, saying that, that is why I have not seconded the ground regarding limitation. Taken objection because that ground was not seconded. Now, the secondly, the actual error, that is that we got paragraph 17.
এটা দিয়া নাই লেখাটো হ্যাঁ? Yes,
Paragraph 17.
17.
Seventh line from fifth line.
Yes,
The type copy of order dated so of the affidavit of opposition which no room for doubt that the respondent had deposited a sum of rupees 50,000 on 17/6/2018. This is the type of, this is the error what they are trying to show. So this is only a typographical mistake. It doesn't have any impact in the case. That's why not, if you are also kindly come to para 11. Para 11. Where is it?
that's no one. Yes,
Therefore, the only question which arises in this case is whether the Lambeth court has committed jurisdictional error in rejecting the petition under section 28(1) of the Specific Review Act by virtue of the impunity. So, you know what happened in this case? When they have filed execution case after receiving the notice of.
no, just tell me seriously, according to you, what is the date of the order and what time was given?
Without appellate court.
No, the time to deposit the money, 50,000. That was order of which order? No, but give the date. Because Mr. Nath is giving us a date,
September 2011.
37, 2011. September, okay, 30 September 2011, yes. Deposit was made.
That was started, the 11 portion is the not,
No, deposit was made within,
deposit was not made, not deposited. They did not deposit it. The review applicant was to deposit it amount.
no, you see, you are saying two things. Number one, you are referring to paragraph 17 and saying the deposit made on 17/6/18 is wrong. Now you are saying it was never deposited. You are yourself referring to para 17. Ah.
As far as the court judgment, which was passed in the year 2011. They have to deposit to pay the amount within 30 days. But they did not do anything. In the year 2016, they have filed an execution. The receipt of the execution, we appeared at we filed an application under section 28. That 28 application was taken into the court legal side by attorney superintendent. Now we got, in that case, they have filed objection. And after hearing the parties, my petition for rescission of contract was rejected. Against that order, behind that order itself, the court, executive, trial court allowed him to deposit the amount.
What is the date of that order?
That was 21/7/2017.
Correct. 1 month time was granted.
1 month.
So he deposited within 21/8/2017. Correct. So this is factually wrong.
Reporting is not wrong, but that
Factually-
doesn't have any impact in the case.
No, it has the impact because you see the view of the court is reflected that he has not deposited within the allowed time. So that is a,
Question was whether they have deposited within the allowed time of the appellate court, because that was the issue.
no, whatever be,
And
it's
they
not a
have
question of,
filed-
it's not a question of what prejudice would cause to him. If it's a factual incorrectness in the order, that has to be rectified.
Rectified.
What consequences would follow is something else. So this 17/6 should be what, according to you? 17/6/18 should be what?
17/8/2017.
17/8/2017.
Fact, page 25, we just may I intervene just for a second minute.
Just a moment.
Just see the page 25. Just over para 11. Just 3 lines. However, it is not disputed that the balance sale consideration of so-and-so was not deposited until 17/8/2007. That is the correct statement. But goes on to add beyond the time allowed by the learned trial court. That is wrong. The date is correct. It is correct. But the rest is not. It is part of para 11, para 10. man.
Okay.
Order pass under section 28 is up in line. Again, the into go to the section 23. Because that's 11%. The court may by order. One order in the and in the section 28, nowhere says that this order is applicable. This order is applicable. Nowhere it is stated. Section 1 below. The court may by order.
Yes.
Nowhere in the section below, it will state or it will mention that this order is appealable order or this order is irrevocable. Nothing is mentioned.
No, in specific relief act, there is nothing mentioned that this order would be a decree. That is nowhere mentioned.
34,
Hmm.
section 34, the word decree is written there.
It was only a declaration. Doesn't say about a decree. Here, only the question of precept is given that once if there's a what do you call, if an instrument is cancelled, precept in form of a decree is sent to the authority which is registering it. That will be, I think, under 31.
Specifically, that there is no for mentioned, but he was decreed there. Now we don't, that needs to be determined, where which we got order 20. Rule 9 onwards. For example, we got section 6 or 5, where which we got order 20, rule 9. Order 20, rule 9.
Just tell me what is the effect of this order under section 28. It is to deposit the money or to order a refund of the what do you call, refund of the money already taken, to restore back.
Either content will be decided or we got that will be extended. Because one can file for rescission and one can file for extension.
So
So in
that just tell me, if I accept your argument, then it will be that the instrument of what do you call this, agreement for sale is rescinded, correct? But it is not a decree. So that means it is kept alive. The rights of the parties, unless there is a decree cancelling that instrument, a mere rescission would be good enough for you.
seven and 28, that is the question. Section 27 has the broad aspect, and 28 has lesser aspect. Under section 28, for rescinding it,
It's simple as that. Answer is very simple. If I am compelled to hear it for more than 5 minutes, it is a broader aspect. If it takes me less than 5 minutes to decide it, it is a lesser aspect.
under 27, consider. Under 28, only thing is that whether he has complied with the decree or not, only this matter. And nothing more than that.
You see, it can't be accepted for a simple reason. Come to section 28 again. Rescission in certain circumstances of contracts for the sale or lease of immovable property, the specific performance of which has been decreed. So you see, a decree, Please see, a decree cannot be set aside and annulled except in appeal. Correct. So if there is a decree, it has to be annulled by an equal strength of order. A mere order would not nullify a decree. You see, that is why when objections are filed under Order 21, Rule 97, 98, 101, what the court does is that it decides the matter, and that becomes that is also considered to be a decree. And against that, appeal is permitted.
Specifically provided under.
It's not a question. You just see this. You will have to see the scheme of the act. You'll have to see the scheme of the act, whether a decree can be annulled by a mere order. Because the decree says, you see section 2.2 of the CPC, what is a decree? Determination of rights. So right which is determined, CPC says it is determined under section 2, subsection 2. It will be very difficult to accept that it can be annulled by something which is lesser than a decree. Is it? I am yet to understand that. We'll understand that in some other day. Because if determination of right is there, that means in a suit nothing is to be decided. Determination of right is already done in injunction.
Temporary right. Temporary right.
No, there is nothing called temporary right or permanent right. The CPC does not define a right to be temporary. It merely says that principles of injunction is that if you find prima facie case, balance of convenience, and you are entitled to pass an order. And this order doesn't have a binding precedent. If you say it declares right even temporarily, you see what right? I merely say you can use this road. It's only a what you call a right which exists to move on that road. When an injunction is given, I say that you can trespass on the road. You can use that road. Tomorrow you can't say that the court has given me a temporary right and therefore I will start construction of a building there. So you have a right, and that right is always circumstanced with the circumstances. The right to stand here will not give you a right to get a patta for this 2 feet by 2 feet of land. So what is that right? That the right is merely a right of usage. Right of permanent injunctions. You are restraining somebody temporarily. And that has got no impact to the decree. But here it impacts a decree. So it's very difficult to accept a proposition that an order under 28, 34.
Declare to be decreased. That is specifically mentioned.
Yes.
So that is decrease.
Don't read in between because it says it refers to title. If you are showing me section 34, 34 is related to title. You read that. Any person entitled to a legal character or to right of any property may institute a suit against any person interested to deny his title to that right.
That declaration is a decrease.
Definitely.
Because the top declaration is decrease.
No, you see, this doesn't take us anywhere. You see, the reason being, you must have read this, I don't know, but please read it with me. In the Specific Relief Act, there is an introduction. The purpose is written like this, introduction. Correct? Read the first line of introduction. That is the only thing which I remember in this. First line of that introduction. No. The introduction of Specific Relief Act is a major legal system endeavors to provide not merely a remedy for every right infringed, but also an adequate remedy. This is the only line I remember in this book. So you see, a right which is granted and a remedy which is granted has to be something which is permanent. That is why we say that there is a decree which gives a permanency to that right. An order within the meaning of this order 41, rule 1 to S, which are appealable. Order 43, rule 1. Yes, A to S, which are appealable. Tell us anything which gives a permanent right. No one. Doesn't create a permanent right. So this argument won't take us anywhere.
Maintaining. At this stage, we have to say, after they have not taken anything. It depends.
You see, in a lighter tone, you remember the English that was spoken by one of the great actors in a movie called Namak Halal. One of the best statements. That was something, she will show something more. Because this is a convincing argument. If section 28, if it is rescinding, that means a decree which has been passed is being rescinded. A rescinding cannot be by way of an order, it has to be by a decree. A right which is finally adjudicated and determined, which becomes a decree within the meaning of order section 2, rule 2. Coupled with the fact that the judgment is after deciding all the issues within the meaning of order 20, rule 10. There's no way that it can't be a decree. Okay, we close it. Yes. Pardon me? 115. Yes.
High Court may make such order as it is fit. But when it suppose no appeal has been high, but lordship has jurisdiction to pass any order which fits. Section has been jurisdiction under section.
Unfortunately, when I see first page of the order, para 1, para 2, I see something else. No. The order which which is under review, which is the order which is under review. First paragraph says something else. Para 2. Yes.
But effect of this revision petition, where we have invoked electricity. And revision issue. High Court is a question.
It's a blunder. We'll have to revoke the order in limine without going into the merit. No. It's not a typographical error because we are assuming jurisdiction. Under Article 227, we don't have that jurisdiction, and these orders were passed on under Article 227. So it will be contrary to jurisdiction. I have to, in limine, withdraw the order. You see, what I do is inherently wrong. What I do is to make the procedures of the code at ease. Your application was under 115 and 227. Now, had it been under 115, it would not have given the court the liberty to entertain, because it would not have disposed of the application. So therefore, in order to make ease of this application, what I do is that I allow you to correct it, and we go under 227, we take that jurisdiction. No, not that. So therefore, today I have learned that this ease of business is ultimately going wrong. Because I do certain things just to ease it. Otherwise, I would have referred the matters to all the matters of this nature to file an amended application. And that would create a lot of difficulty. So what I do is that I ask the lawyers to either strike it out, or we treat this application as under 227 and we go ahead. We are not putting the lawyers to inconvenience. But if that is read against the court, then what you call, ultimately we are, the common man know how to use the what you call screwdriver. Screwing up things is very easy. To make the what you call task easier for the court, we allow so much of amendments, corrections in the courtroom. I do it because I don't want the lawyers to be to be affected, because to file for everything an application, amendment, correction, it will take a lot of time. I do certain things just because I have I rely on the lawyers and permit that. So therefore, 115, it had you see composite application under 115 and 227 is not maintainable. Not only there is judgment authored by me, but there is also Supreme Court judgment to support me. 115 and 227 cannot travel together in the same boat. No, you see, because if we come down to giving that strict interpretation, then I can assure you, most of you will be affected. In a civil appeal, I issue notices under Section 5 of the Limitation Act. Whereas the CPC says under 41 Rule 3, 3A, it should be the application under 3A. So there are many things I condone on the ground that it will create a what you call it will create hurdles on the path of the lawyer to do it. In second appeal, regularly we issue notices under condemnation of petition under Section 5. If I go strictly, it would all be dismissed. So I am aware what I am doing. That's why when you said that it's 115, I immediately said that we'll recall the order immediately, because it is a assumption of an erroneous jurisdiction. You don't even have to go into the merit. There's written argument and everything that goes for a sixer.
I gave the order passed under Section 28. 115 is maintainable.
Why? If it is held that it's a decree, then the appeal would lie. No. You see, there's several things. When I'm saying something, there are several things in the mind. Number one, you see, if your application was under 115, I treat it as 227. I'm assuming a different jurisdiction, which I'm not permitted to. You see, it has to be an order of conversion of an application from 115 to 227. No, I'm not on what is there, what is not. But if you take that plea, if the application is under 115, I treat it as 227. Therefore, I am assuming a jurisdiction which was not there at all. That itself is a ground to recall it. No. You see, 115 and 227, what is the effect of the order? I don't know. But if our application is under 115, I am treating it as 227. It's an innate lack of jurisdiction.
115 is always applicable because we got two types of interim order.
No, no, that's okay. I'm agreeing to it. I'm agreeing to it, but my order is under 2 to 7.
That is the typographical mistake.
No, no, I won't take it as a typographical error. I'm assuming a jurisdiction. By typing error, I can't assume jurisdiction.
Paragraph 11, itself, you know,
No, I'll take care of it
paragraph 11, you know,
because I don't have to go anywhere now. You have shown me the road.
paragraph, therefore, the only question which arises in the case whether the learned court has committed jurisdictional error. That 115 is there, you know. And this
We'll pass an order when we take up 115. We'll pass that order again if required under 115. But assumption of jurisdiction is inherent lack of jurisdiction. If the court has committed a wrong, the Supreme Court has said the court should not shy away from accepting that it has committed a wrong. If I have committed a mistake, I should not shy away. I should not take shelter of any typing error or something and then say, no, no, this I'll justify my error. Justification of error can't be done. The court, if court has committed a mistake, it has committed a mistake. And to err is human. We make mistakes. That is why there is appellate court. That is why there is review. That is why there is revision. Nobody can say it's perfect. No,
even if it is written as.
no, it can't be done. We'll pass orders. But it will fix day after tomorrow for delivery of orders. No, make it third. Don't make it now. Mr. M. Nath, N. Nath, counsel for the applicant, review petitioner, and Mr. S. Sahul Leonard, counsel for the respondent, both respondents. Both sides, in addition to oral argument, have also filed their written note of the written synopsis of their submissions. The same is made a part of record. Fix on so and so. He
Three to be a-
no 3. Make it 4. Huh?
4.
4.
This is 4 হলে ভালো।
4 করে. Okay. Either 4 or 5 for delivery of orders. 4-1. That corrections you have done, you have given it. Okay. Really don't think I would have time for anything else today. Because today I am also to go to that program of Honorable Justice D.N. Chaudhary. So today I have to rise at the time. Interim orders are there to tell him, otherwise we are not giving any orders in these 2-3 days. Will be some difficulties.
May I please? Item number 52, last item. I have some urgency.
You make a mention because we are not doing it. We won't be able to handle in these 2 days. It's rolled over, you make a mention. You make a mention, we are not passing any orders. In item number 43. He's for appellant. Respond number. The positive time matter could not be taken up today. The counsel for the respondent numbers 1 and 2 submits that she is led by Mr. Shishir Datta, senior counsel, whose name is not reflected in the cost list. The registry shall reflect the name of Mr. Shishir Datta, senior counsel, as appearing on instructions of the instructing counsel for respondent numbers 2 and 3. List of the ensuing vacation. You're not fixing a date, they can make a mention if required.
Item 5, my lord. For matter. Excellent.
Item 5. What is that?
Taken there.
Just a moment. Item 5, just show that item. But written statement can't be permitted. There's a lot of adjournments.
Everything, my lord, during COVID period and the, my lord, because expertise order was not communicated to the petitioner. my lord.
You can't help that. You see the default continued even after that COVID was over.
And even after my lord, expertise order, my lord, he was, my counsel was allowed to appear, my lord, and his application was accepted by the child court.
And his,
And,
what happened? He was allowed to appear and
and his application for, my lord, submitting documents was allowed, my lord. In the last occasion, my lord, it was come to the knowledge that, and on 12/12/2022, my lord, petition was rejected. And
that that would not matter, but your default is appellant. Not only one, there is a continuous default. Time of written statement is 90 days. We can't extend that.
one thing, my lord,
You see, we could have understood your bona fide if you had you filed your written statement before the trial court. That was not done.
at that period of time, my lord, COVID was going on, my lord, and reopening was not communicated. All documents were, my lord, furnished to the learned advocate, my lord, who conducted the case.
Mr. Hari, we can't allow these persistent defaults. COVID, okay, extension of COVID, as per the Supreme Court judgment, we can always accept that. But after that, COVID restrictions were not there. Then you can't accept that. Because the order to pass, to order to proceed, the ex parte was passed, I think, after the COVID.
No, during COVID, 19/4/2021. And thereafter, my lord, we appeared, both the parties appeared. And finally, my lord, 12/12/2022, my lord, final order was passed. After, my lord,
As per this order of Supreme Court in Suo Motu 3, what is the period of COVID?
my lord, up to, my lord, 22/2022, from 15 March to 20.
2022.
Lordship.
So after that, it shows what is your
From March
conduct?
of 22.
After this 2022, what is your status of default?
But after, my lord, my lord, I appeared, my lord, up to 12/12/2020. On 12/12/22, my lord, we filed a application for furnishing document. on that day, my lord, ex parte order was came to knowledge of the, my lord, time. Therefore, my lord, application rejected and should proceed ex parte. Is 30, my lord, first order.
No, sir, he will be declining. You can't allow this. House orders in chambers. I would not have time now. Yes,
We may be allowed to, my lord, file application under rule, my lord, order 9, rule 7.
no, we won't say anything. We just allow your prayer. We won't make any comment. Mr. R. Alil and counsel for the petitioner prays to permit him to withdraw this application and to move the learned trial court under order
9, rule 7.
under order 927 CPC. Full stop. Next, on such prayer, the court is of the considered opinion that the leave of the court is not required to move the trial court under any provision of law. Full stop. Next, nonetheless, comma, the petitioner is permitted to withdraw this application and take such appropriate remedy as may be so advised. As they may be so advised. Yes?
If we continue to delay petition versus the MSAP.
No, we are not passing orders in between because there's some administrative problems. We'll take up another day.
After vacation.
I don't know, we are asking for rollover, but we don't know when the matters will be listed. Make a mention if it is not.
Item 15 in the connected there is a interim order which will be continued.
Just tell the court master. Interim order if it is there, tell the court master. Just tell the court master, we will do it. Extension of interim order, will do it.